Bismillah ar-Rahman ar-Rahim. Introduction to Paralegalism, Perspectives, Problems, and Skills, 9th edition. How to study law in the classroom and on the job. Narrated by Omar Mohsen Ibrahim Fouad. Chapter Introduction. Objectives. After completing this section, you should be able to describe why legal education is a lifelong pursuit. Distinguish between substantive and procedural law and rules and skills. Explain the importance of a study plan. Prepare a self-assessment of your study habits. Create a self-assessment of grammar, spelling, and composition skills. Value the importance of mastering the definitions and studying the law. Develop better note-taking skills. Create a checklist for major assignments. Write instructions from assignments into checklists. Illustrate the value of models, background research, continuing legal education, and evaluations in studying the law in the classroom and on the job. What if it's your first day of work as a paralegal? You are excited, yet a bit nervous. You don't really know what to expect. Of course, you arrive bright and early at your new law firm and are greeted by a friendly receptionist. After an introduction to the office procedures by the Director of Human Resources, you are briefed about your responsibilities and are immediately escorted to a small office. Yes, your own office. Immediately, you are whisked into a meeting on an important case involving someone who was injured in a construction site accident. From what you can tell, a huge concrete slab fell on the worker and killed him. The firm represents the parents of the deceased worker. Their 28-year-old son. The construction company believes that the construction worker was intoxicated on the job. The parents know that their son was allergic to alcohol so it could not have been his fault. There are 3 other paralegals in the room, along with a team of attorneys discussing the case. Depositions are set for next week, and each paralegal in the room has been asked. Each paralegal in the room has been tasked with an assignment. Your assignment is to review all the prior depositions of witnesses and summarize them for the team. You only did that in a class assignment. What do you do? How do you approach this problem? This is a typical fact scenario that you will encounter when you become a paralegal. What this introduction to studying in the classroom and on the job will assist you in learning is how to best address this type of issue. As we move through this section and future chapters, we will learn different approaches to answering the question posed. What do you do, or how do you approach this problem? As you will learn, there is not one answer to these questions, but thinking strategically, thoughtfully, and most importantly, calmly, will assist you in determining the options available and the best approach. Let's begin with learning and approaching how to study law in the classroom and on the job. Getting started, classroom learning. Beginning your paralegal education will be an exciting time. You are learning about a new profession, which will involve learning new skills. With this will come an adjustment period while you learn new skills and a new language. The language of the law. It may seem a bit overwhelming at first, but with time, it does get easier. We all have been there, whether starting a paralegal program or even law school. As the old adage says, Rome wasn't built in a day. So be forgiving to yourself and know that it will take time to get the hang of things. Studying the law is a totally new realm of training. Much of the material will seem foreign and daunting, but know that you will get there and master the subject. Although there is a danger of becoming overwhelmed by the vast quantity of laws and legal material that confront you, your instructors and your supervisors will help you navigate this process. So you may ask yourself, how do you study law? How do you learn law? What is the proper perspective that a student of law should have about the educational process? These are our objectives in this introduction to the process of studying law. The art of effective learning and effective studying. 1. Your legal education has 2 phases. Phase 1 begins now and ends when you complete this training program. Phase 2 begins when this training program ends and is not completed until the last day of your employment as a paralegal. You have entered a career that will require you to be a perpetual student. The learning will always continue. This is true, not only because the boundary lines of law are vast, but also because the law is changing every day. No one knows all of the law. Phase 1 of your legal education is designed to provide you with the foundation that will enable you to become a good student and ultimately a successful paralegal. In phase 2, your legal education has 2 dimensions: the content of the law, the rules, and the practical techniques of using that content in a law office, the skills. Rules. There are 2 basic kinds of rules or laws: substantive law, the non-procedural rules that define or govern rights and duties. Important example, the requirements for the sale of land and the elements of an assault. Procedural law, the rules that govern the mechanics of resolving a dispute in court or in an administrative agency. Important example, a rule on the time by which a party must respond to a complaint or the time frame when you have to file an appeal. In the past, the law library was the depository for all legal material. But with the internet, the law library is now accessible in electronic form through online libraries such as Westlaw, LexisNexis, or FindLaw. Both the law library and online sites contains millions of substantive and procedural laws written by courts in volumes called reporters, by legislators in volumes called statutory codes, and by administrative agencies in volumes called administrative codes. A substantial portion of your time in school will involve the study of the substantive and procedural law of your state, and often of the federal government as well. Knowing how to find this information as you will learn will be an important aspect of your legal education. Developing your skills. By far, the most important dimension of your legal education will be the skills of using rules, applying the rules of law to the facts presented by a case. Whether you're instructor or supervising attorney, whether by your instructor or supervising attorney. By not learning these skills, paralegals and attorneys would be lost. Mastering these skills is important. Examples of legal skills include how to analyze the facts of a client's case in order to identify legal issues. See Chapter 8. How to do a site check or perform other legal research in traditional and online law libraries. See Chapter 9. How to draft a complaint, the document that initiates a lawsuit. See Chapter 14. How to digest or summarize data found in discovery documents. See Chapter 14. How to investigate the facts of a case. See Chapter 13. How to write a search query for an online database. See Chapter 11. How to interview a client. See Chapter 12. The overriding skill that, to one degree or another, is the basis for all others is the skill of legal analysis. Chapter 8. Remember, legal analysis is not the exclusive domain of the attorney. You too must master legal analysis. Without an understanding of at least the fundamentals of legal analysis, however, paralegals cannot understand the legal system and cannot carry out many of the tasks they are assigned. 3. The study of law is different than an episode of a television drama. What you thought you knew or experienced will be different in practice. Everyone knows something about the law from taking government or civics courses as a teenager and from the various treatments of the law in the media. Some of you may have been involved in the law as a party or as a witness in court. Others may have worked or currently work in law offices. But the formal study of law will be different, and your journey would not be the same as an episode of Law and Order on TV or a movie. Furthermore, TV and movies sometimes give the impression that all attorneys are trial attorneys, and that most cases are solved by dramatically tricking a hostile witness on the stand into finally telling the truth. Not so. The practice of law is not an endless series of confessions and concessions that are pried loose from opponents. Every attorney does not spend all day engaged in the kind of case that makes front page news. A New Jersey paralegal left their job with a sole practitioner to take another paralegal position with a law firm that they thought was going to be like the one on the TV drama they faithfully watched every week. Three months later, they begged their old boss to take them back after discovering the huge gap between reality and the law office on that show. Another potentially misleading portrayal of the law came in the O.J. Simpson criminal and civil trials, which captivated the nation in the late 1990s. Very few parties to litigation have teams of attorneys, investigators, and experts ready to do battle with each other as they did in the Simpson trials. The vast majority of legal disputes are never litigated in court. Most are either settled or simply dropped by one or both parties. Of the small number that are litigated or culminate in a trial, most involve no more than two opposing attorneys and several witnesses. In short, it is rare for the legal system to become the spectacle that the occasional high-profile case leads us to believe is common in the practice of law. While excitement and drama can be part of the legal system, they are not everyday occurrences. What is dominant is painstaking and meticulous hard work. This reality is almost never portrayed in the media. Keep an open mind in your educational process and suspend the notion, at least temporarily, of what you already knew or thought you knew. Every new instructor, every new supervisor, every new setting is an opportunity to add a dimension to your prior knowledge and experience. Be open to these opportunities. No two people practice law exactly the same way. Your own growth as a student and as a paralegal will depend in large part on your capacity to listen for, explore, and absorb this diversity. 4. Be sure that you know the goals and context of every assignment. Throughout your education, you will be given a variety of assignments: class exercises, text readings, drafting tasks, field projects, research assignments, etc. You should ask yourself the following questions about each one. What are the goals of this assignment? What am I supposed to learn from it? How does this assignment fit into what I already have learned? What is the context of the assignment? For assignments from your textbook, carefully examine a table of contents, chapter objectives, and the variety of headings in a chapter in order to grasp the broader picture into which an assignment fits. Ask questions if the purpose of an assignment and its relationship to paralegalism is not clear. Successfully completing an assignment depends in part on understanding its goals and how these goals relate to the overall context of the course and the career. Think about the fact pattern at the beginning of this section. Think about the questions that you should be asking to have a better understanding of the assignment presented. We will focus on that later in this section. Five, design a study plan. Make current lists of everything that you must do in each of your courses. Update the lists regularly. Divide every list into long-term projects. What is due next week or at the end of the semester? And short-term projects. What is due tomorrow? Essentially, stay organized. Have a plan for each day. Establish the following schedule for yourself. Every day, you will make some progress on everything on your long-term and short-term lists. Priority, of course, will be given to the short-term tasks. Yet, some time, however small, will also be devoted to the long-term tasks. For example, on a day that you will be mainly working on the short-term projects, try to set aside some time for a long-term project by doing some background reading or by preparing a rough first draft of an outline. Maybe all you can do on an assignment is read a paragraph or review what needs to be done on the assignment. It is critical that you establish a plan toward the accomplishment of all your tasks. Try and make at least some progress on everything every day, and at the very least, revisit your plan every few days so you do not get behind. This will aid in successfully meeting your goals and attaining the ultimate prize, becoming a paralegal. Once you have decided what tasks you will cover on a given study day, The next question becomes the order in which will you cover them. There are a number of ways in which you can classify the things you must do. For example, you can classify them as easy tasks that will require a relatively short time to complete, complex tasks requiring more time, and tasks with time demands that will be unknown until you start them. At the beginning of your study time, spend a few moments preparing an outline of the order in which you will cover the tasks that day and the approximate amount of time that you will set aside for each task. You may want to start with some of the easier tasks so that you can feel a sense of accomplishment relatively soon. Alternatively, you may want to devote early study time to the third kind of task listed above so that you can obtain a clearer idea of the scope and difficulty of such assignments. The important point is that you establish a schedule. It does not have to be written in stone. Quite the contrary. It is realistic to have enough flexibility to revise your day's schedule so that you can respond to unfolding realities as you study, just like you will experience when you are on the job. Being adaptable is an important characteristic of studying and, in turn, practicing the law. Have a plan, but know that things change, and adapting to that change is an important component of your legal education and being a part of the legal profession. Six, set aside time to devote to studying a subject and then add some more. The conscientious study of law takes time, lots of it. Try and plan what time you will devote to your studies. For many of us, engaging in a paralegal program is not our only responsibility. It is true that some students must work or take care of family responsibilities. You cannot devote time that you do not have, but you do need to learn to manage and be efficient with the time you do have. This is something you will have to figure out. Sacrifices will be made, but know it will all be worth it when you reach your goal of becoming a paralegal. Look for ways to fit study time into your other activities. Always carry something to study. in the event that time becomes available. For example, photocopy, scan, or photograph a portion of a chapter in a class textbook and bring it with you whenever you can. It might be perfect for that unexpectedly long wait at the dentist's office. There are no absolute rules on how much time you will need to study law. It depends on the complexity of the subject matter you must master. It is probably accurate to say that most of us need to study more than we do. Therefore, learn to manage your time efficiently to make the most of opportunities to study and learn your craft, the law. Resolving time management problems as a student will be good practice for you when you are confronted with similar and more severe time managing problems as a working paralegal. Many law offices operate at a hectic pace. One of the hallmarks of a professional is an understanding for deadlines and the clock. Learn to make the most of your days and acquire a reputation for hard work, punctuality, and appreciation for time needed to devote to studying and working. Seven, create your own study area free from distractions. It is essential that you find study areas that are quiet and free from distractions. Otherwise, concentration is challenging. It may be that the worst places to study are at home or at the library, unless you can find a corner that is cut off from noise and people who want to talk. If possible, study away from phones, TVs, or any other types of distractions. Do not make yourself available except for emergencies. If you study in the corridor, at the first table, at the entrance to the library, or at the kitchen table, you are inviting distraction. You need to be able to close yourself off for 2 to 3 hours at a time. It is important for you to interact with other people, but not while you are studying material that requires considerable concentration. You will be tempted to digress and to socialize. You are undoubtedly in the best position to know where these temptations are. You are also the most qualified person to know how to avoid the temptations. 8. Establish a study program that works for you. Everyone studies differently and at different paces. Establish a plan for yourself that is workable. Which item on my plan am I going to work on today or tonight? What will the plan be for this week, for next week, for the coming month? The reality is that studying is not fun. Many of us procrastinate and get easily bored. We make excuses as to why we don't need or want to study. We make excuses such as, I can't concentrate, or I'll just listen in class to get by. That will not be enough to be successful as a student or professional in the law. You need to stay focused and follow your study plan without excuses or distractions. You must create effective study techniques to be successful in the law. Start now as you begin your legal studies. Creating good study habits at the beginning of your training will impart good habits when you become a working paralegal. 9. Engage in active studying. Even without distractions, the mind often wanders away from what should be the focus of what we are studying. Daydreaming during study time is not uncommon. If this occurs, do some active studying by forcing yourself to do something other than or in addition to reading. For example, write out definitions of key terms. Create your own chart or graph that contains pieces or components of a topic you are studying. Create mnemonics to help you remember important concepts. On mnemonics, see section 16 below. 10. Conduct a refresher on grammar, spelling, and composition. Work on remastering these ideas. The legal profession lives by the written word. Talking is important for some activities, but writing is crucial in almost every area of law. You cannot function in this environment without a good grasp of the basics of grammar, spelling, and composition. Here are 7 steps that will help solve it. Step 1. Take responsibility for your training in grammar, spelling, and composition. Make a personal commitment to train or retrain yourself. If English courses are available to you, great. There are online sites specifically on grammar, spelling, and composition. YouTube offers videos that may be helpful as well. Step 2. Raise your consciousness about the writing around you. When you are reading a newspaper, for example, traditional or online, try to be conscious of semicolons and paragraph structure in what you are reading. At least occasionally, ask yourself why a certain punctuation mark was used by a writer. You are surrounded by writing. You read this writing for content. Begin a conscious effort to focus on the structure of the writing as well. Step 3. Commit yourself to spending 10 minutes a day, 5 or 6 days a week, on improving your grammar skills, for a total of about an hour a week. Drill yourself on the fundamentals of language. One way to test your progress is to try the exercises on different sites. Suppose, for example, you are on a site that discusses the use of commas in that clauses and which clauses. After you finish the that and which exercises at this site, go to another grammar site and find its section on that and which. Read the examples and do the exercises at this site. Are you reinforcing what you learned at the first site? Or are the examples and exercises at the second site making you realize that you need more work understanding this area of grammar? Using more than one site in this way will help you assess how well you are grasping the material. Step 4. Improve your spelling. Use a dictionary often. Begin making a list of words that you are spelling incorrectly. Work on these words. Ask other students, relatives, or friends to test you on them by reading the words to you one by one. Spell the words aloud or on paper. You can drill yourself into perfection or close to it by this method. When you have the slightest doubt about the spelling of a word, check the dictionary. Add difficult words to your list. Again, the more often you take this approach now, the less often you will need to use the dictionary later. Use the internet as a resource. In Google, Bing, or Yahoo, run this search. Spelling rules You will be led to sites that will provide guidance. Many word processing programs, important example, Microsoft Word, have spell checkers that not only identify words you may have misspelled, but also provide suggested corrections. Does this new technology mean that your spelling problems have been solved forever? Unfortunately, the answer is no. Spell checkers can catch many spelling blunders, but they can be very misleading. First of all, they cannot tell you how to spell many proper names, such as the surnames of individuals, unless you add these names to the base of words being checked. An even more serious problem is that spell checkers do not alert you to improper word choices. Every word in the following sentence, for example, is incorrect. But a spell checker would tell you that the sentence has no spelling problems. It's too later to buy diner. Here is what should have been written. It's too late to buy dinner. Because the first sentence has no misspellings. You are led, that is, misled to believe that you have written a flawless sentence. Additionally, a spell checker does not catch missed words. If you are writing a sentence that should contain the word not, but omit it, the spell checker will not catch that error. For example, the winning party to the lawsuit will not be responsible for attorney's fees. However, you type, the winning party to the lawsuit will be responsible for attorney's fees. The spell checker will not pick up the missed word not. The meaning of the sentence is completely changed. Be vigilant in checking your spelling and the content. Step 5. Enroll in English and writing courses. Find out if drop-in, help labs, or remedial centers are available to you. Check offerings at local schools, such as adult education programs in the public schools or at colleges. Step 6. Find out which law courses in your curriculum require the most writing from students. If possible, take these courses to improve and refine your writing skills. Writing is not easy for everyone and takes time and practice. The more you do it, the better you will become. Therefore, try and place yourself in an environment where writing is demanded of you on a regular basis. In the long term, it will be a blessing in disguise. Step 7. Simplify your writing. Cut down the length of your sentences. Often, a long-winded sentence can be effectively rewritten into shorter sentences. How can you tell if your sentences are too long? There are, of course, no absolute rules that will answer this question. Yet, there is a general consensus that sentences on legal topics tend to be too long. If a sentence runs more than 3 typed lines, chances are it is getting too long and unclear. Take the time to check the sentence and determine whether it is better to rewrite the sentence for clarity. More will be discussed on this topic in Chapter 10. As you review sentences you have written, you should be asking yourself self-editing questions such as, would I have been clearer if I had made that sentence shorter? To recap, set aside a small amount of time each day to work on writing. Be consistent about this time. Progress may be slow, and you will be on your own, but keep working through it. Know that the more you work on writing, the better you will get. Practice may not make you perfect, but practice will make you better. (11) Consider forming a student study group. Students sometimes find it useful to form study groups. A healthy exchange with your colleagues can be very productive. Try and find students with whom you are compatible. Trial and error may be the only way to identify such students. A more serious concern is trying to define the purpose of the study group. It should not be used as a substitute for your own individual study. Course review, however, is an appropriate group task. Divide a course into parts, with each member of the group having responsibility for reviewing their assigned part with the rest of the group. "12. Use your legal research skills to help you understand components of a course that are giving you difficulty. The law library, whether online or the traditional brick and mortar building, is more than the place to go to find law that governs the facts of a client's case. A great deal of the material in traditional and online law libraries consists of explanations, summaries, and overviews of the same law that you will be covering in your courses. See Chapter 9 on doing relatively quick background research on any legal topic. Such research will be invaluable as outside reading to help resolve conceptual and practical difficulties you are having in class. 13. Organize your learning through definitions or definitional questions. Among the most sophisticated questions an attorney or paralegal can ask are these: what does that word or phrase mean? Should it be defined broadly or narrowly? To a very large extent, the practice of law is a probing for definitions of keywords or phrases in the context of facts that have arisen. Can a 5-year-old be liable for negligence? What is negligence? Can the government tax a church-run bingo game? What is the free exercise of religion? Can attorneys in a law firm go on strike and obtain the protection of the National Labor Relations Act? What is a covered employee under the labor statute? Can one spouse rape another? What is the definition of rape? Can a citizen slander the President of the United States? What is a defamatory statement? In every course that you take, you will come across numerous technical words and phrases in class and in your readings. Begin compiling a list of the major words and phrases for each class. When in doubt about whether to include something on your list, resolve the doubt by including it. Then pursue definitions. Find definitions in class lectures, your textbook, a legal dictionary, or a legal encyclopedia. For legal dictionaries online, type legal dictionary in Google, Bing, or Yahoo. For some words, you may have difficulty obtaining definitions. Do not give up your pursuit. Keep searching, keep probing, keep questioning. For some words, there may be more than one definition. Others may require definitions of the definitions. Of course, you cannot master a course simply by knowing the definitions of all the key words and phrases covered in the course. Yet these words and phrases are the vocabulary of the course and are the foundation and point of reference for learning the other aspects of the course. Begin with vocabulary. Consider starting a system of 3x5 or 2x3 cards, sheets of paper, or electronically to help you learn the definitions. On one side, place a single word or phrase. On the other side, write the definition with a brief page, reference, or citation to the source of the definition. This can be created electronically as well, using the cards, sheets, or electronic version. Test yourself periodically. If you are in a study group, ask other members to test you. Ask a relative to test you. Establish a plan of ongoing review. 14. Study ambiguity. Coping with unanswered questions. Legal studies can be frustrating because there is so much uncertainty in the law. Legions of unanswered questions exist. Definitive answers to legal questions are not always easy to find, no matter how good your research techniques are. Every new fact situation presents the potential for a new law. Every law seems to have an exception. Furthermore, advocates frequently argue for exceptions to the exceptions. As indicated, when terms are defined, the definitions often need definitions. The study of law is in large measure an examination of ambiguity that is identified, dissected, and argued. Search for as much clarity as you can, but do not be surprised if the conclusion of your search brings further questions. A time-honored answer to many legal questions is, it depends. The practice of law may sometimes appear to be an endless puzzle. Again, look for precision and clarity, but do not expect the puzzles to disappear. (15) Develop the skill of note-taking. Note-taking is an important skill for getting the most out of your formal education. In addition, effective note-taking is often a precondition to many law office tasks. Take notes on what you are reading for class preparation and for research assignments. Never rely exclusively on your memory. After reading hundreds of pages or more in textbooks and online, you will not be able to remember what you have read at the end of the semester or even at the end of the day. Copy what you think are the essential portions of the materials you are reading. Include definitions of important words and phrases as indicated in Guideline 13 above. In addition to, and not as a substitute for, taking written notes on your readings, mark up the text if you own it. Use different colors. Underline and highlight what appears to be important. Circle or electronically highlight keywords. Don't read passively. Read with your eyes and hands. To be sure, note-taking will add time to your studying, yet you will discover that it was time well spent, particularly when you begin reviewing for an exam or writing a memorandum. In class, you must develop the art of taking notes while simultaneously listening to what is being said. On the job, you will have to do this frequently, such as when receiving instructions from a supervisor, talking with someone on the phone, doing a follow-up interview of a client, interviewing a witness during field investigation. If your supervisor asks you to attend a deposition or a trial, you may need to take detailed notes on the testimony of a particular witness. A deposition, as you will learn in Chapter 14, is a method of discovery by which parties and their prospective witnesses are questioned outside the courtroom before trial. A good place to begin learning how to write and listen at the same time is during your classes. Note-taking is a learned skill, and many students have challenges taking good class notes. This is due to a number of reasons. They write or type slowly. They don't like to take notes. It's hard work. They don't know if what is being said is important enough to be noted until after it is said. When it is too late because the instructor has gone on to something else. They don't think it's necessary to take notes on a discussion that the instructor is having with another student. They don't think it's necessary to take notes on a topic that's covered in the textbook. They take notes only when they see other students taking notes. Some instructors ramble. You must try and overcome whatever resistance you have acquired to the admittedly difficult task of note-taking. As you will learn, it is an essential skill in the legal profession and, in turn, an essential skill for you becoming a paralegal. Develop your own shorthand system of abbreviations for note-taking. Here are some commonly used abbreviations in the law. Some of the terms have more than one abbreviation. Pick the one that works best for you. A. Action. AA. Administrative agency. A/C. Appellate court. AFF. Affirmed. AKA, also known as ANS, answer. APP, appeal. APPEE, appellee. APPNT, appellant. AR, administrative regulation. A/R, assumption of risk. ASSN, association. ATTY, attorney. If you can't hear the instructor, move closer or ask the instructor to speak up. Ask the instructor to repeat something you missed. Ask the instructor whether taping the class is permissible so that you can continue note-taking while listening to the tape. If you are participating in class by talking with the instructor, it will obviously be difficult for you to take notes at the same time, After class, take a few moments to jot down some notes on what occurred during the discussion. Then ask someone else who was in class to review these notes for accuracy and completeness. Sometimes you will have to begin taking notes at the moment the person starts talking, rather than wait until the end of the day of what they are saying. Sometimes you will have to begin taking notes at the moment the person starts talking, rather than wait until the end of what they are saying. Trying different approaches to increasing the completeness of your notes. For those who prefer writing notes by hand, don't fill up the entire sheets of paper with notes. Keep at least a 3-inch right-hand margin that is blank while you take notes. Later, fill in these empty spaces with notes on things you missed in the lecture or that you better understood as the class progressed. Read the notes of fellow students. When their notes contain material you missed, copy it into the right margin space. Sometimes so much is happening and being said during a class that it is difficult to take notes. When this happens, at least write down what appear to be key nouns or verbs that the instructor uses. Leave additional space around these words so that you can come back later and fill in details and context that you may have missed initially. Nowadays, many students are taking notes on computers, tablets, or by other electronic means. There are programs that assist in note-taking such as Microsoft OneNote, Google Keep, Evernote, and many others. Depending on your needs, may depend upon the program or app you use, regardless as to whether you are a traditional pen and paper person or prefer an electronic version. Note-taking is an important skill to master both in the classroom and in your professional life. Additionally, pay particular attention to definitions and lists. Every time the instructor defines something, be sure your notes record the definition exactly. Sometimes instructors will redefine the same term with slight modifications. Take notes on the modifications because they will often help clarify what is being discussed. Also, be conscientious about lists. An instructor might begin a topic by saying that there are 3 elements to a particular rule, or that we will be examining 4 major categories of examples of the kinds of cases that can arise. When you hear that a list is coming by such language, have your pen at the ready. Lists of this kind are very important in law. As noted, the suggested approach above follows on an electronic device as well. The end result is that you have to determine the best method for your style of note-taking. There are no hard and fast rules. You should be guided by what works for you. 16. Studying rules. The role of memory. Memory plays a significant role in the law. Applicants for the bar, for example, are not allowed to take notes into the exam room. An advocate in court or at an administrative hearing may be able to refer to notes, but the notes are of little value if the advocate does not have a solid grasp of the case. Most of the courses you will be taking have a memory component. This is true even for open exams. This is true even for open book exams. You will not have time to go through all the course material while responding to questions. Many systems for memorizing material can be effective. Reading it over and over, copying and recopying important parts of it, having other students ask you questions about it, making summaries or outlines of it, tape recording yourself reading difficult material from a textbook and playing the tape back while driving or doing house chores, creating your own mnemonics. Mnemonics are simply aids to memory that you create or adopt. The most common mnemonics consist of a series of letters that represent items on a list. For example, suppose you are studying section statute 100, an important larceny statute in criminal law, which requires proof of the following three elements: intent to steal, personal property, resulting financial harm. To help you remember these elements, you could assign the letter I to the first element, P to the second, and R to the third. You can then scramble these letters to make the word RIP. Resulting financial harm, R. Intent to steal, I. Personal property, P. The word RIP can now be used to help you remember the elements of statute 100. Easy to remember words, important example, RIP, or non-words, important example, GGET or ANAR, can be useful mnemonics. You are in control of the letters to be assigned to items on the list. Your goal is to come up with something that will help you recall the list. Therefore, the only criterion is to come up with something memorable. If you do not have a photographic mind, you must resort to such techniques. Try different systems. Ask other students for tips on how they memorize material. You will have to find out from your instructor what material you will be expected to know for the course. You can also check with other students who have had this instructor in the past. It may not always be easy to find out how much an instructor expects you to know from memory. Instructors have been known to surprise students on examinations. Thus, it is important to be as prepared as possible by utilizing and understanding the techniques for studying that will contribute to your success at becoming a paralegal. 17. Studying skills. The necessity of feedback. Memory is most important when you are studying the basic principles of substantive and procedural law. Memory plays a less significant role in learning the skills of interviewing, investigation, legal analysis, drafting, coordinating, digesting, and advocacy. These skills have their own vocabulary that you must know, but it is your judgmental rather than your memory faculties that are key to becoming competent in such skills. They are developed primarily by practice, drills, or exercises. The learning comes from the feedback that you obtain while engaged in these skill exercises. What are the ways to obtain feedback? Evaluations on assignments and exams, role-playing exercises that are critiqued in class, comparisons between your work, particularly writing projects, and models that are provided by the instructor or that you find on your own in the library. Critiques that you receive from students in study groups. Be constantly looking for feedback. Do not wait to be called on. Do not wait to see what feedback is planned for you at the end of the course. Take the initiative. Seek conferences or email contact with your instructors. Find out who is available to read your writing or to observe your performance in any of the other skills. Set up your own role-playing sessions with your fellow students. Seek critiques of your rewrites, even if rewriting was not required. Create your own hypotheticals for analysis in study groups. A hypothetical is simply a set of facts invented for the purpose of discussion and analysis. Do additional reading on these skills. In short, become actively involved in your own skill development. 18. Reading for comprehension. Learning to read the law is not always an easy process, especially in the beginning. New words and new concepts abound. Much time in the beginning may be devoted to looking up the meaning of words to understand the context. If you are troubled by how long it takes you to read, do not despair. Keep reading. Keep rereading. The pace of your reading will pick up as you gain experience. Never strive, however, to be able to fly through the material. Strive for comprehensiveness. Strive for understanding. For most of us, this will come through the slow process of note-taking and rereading. Reading legal material calls for careful thinking about what you read and taking notes on these thoughts. There may be no harm in rapidly reading something for the first time, but for total comprehension of the subjects you are studying, read at a slower, more deliberate pace. On-the-job learning, the art of being supervised. A great deal of learning will occur when you are on the job. Some of it may come through formal in-house office training and by the study of office procedure manuals. Most of the learning, however, will come in day-to-day interactions with your supervisors as you are given assignments. The learning comes through being supervised. Here are some guidelines to assist you in this important dimension of your legal education. 1. Ask questions when receiving the instructions about an assignment. When paralegals are receiving instructions on an assignment, they often pretend that they understand all the instructions, but in fact do not. They do not want to appear to be uninformed, especially at the start of a new job. They do not want to give the impression that they are unsure of themselves, for obvious reasons. This is not the best approach. Whenever you are given an assignment in a new era, that is, an assignment on something that you have not done before, there should be a great deal that you do not understand. This is particularly true during your first few months on the job. When just about everything is new, do not pretend to be something you are not. Constantly ask questions about new things. Do not be reluctant to ask for explanations. Do not assume that the instructions will become clear to you after you start the assignment. Ask for help at the outset. It will not be a sign of weakness. Quite the contrary, people who take steps to make sure that they fully understand all the instructions they receive will soon gain a reputation for responsibility and conscientiousness. 2. Repeat the instructions to your supervisor before you leave the room. Once your supervisor has told you what they want you to do, do not leave the room in silence or with the general observation, I'll get on that right away. Repeat the instructions back to the supervisor as you understand them. Make sure that you and your supervisor are on the same wavelength by summarizing what you think you were told to do. This will be an excellent opportunity for the supervisor to determine what you did or did not understand and to provide clarifications where needed. Supervisors will not always be sure of what they want. By trying to obtain clarity on the instructions, you are providing them with the opportunity to think through what they want done. In the middle of the session with you, the supervisor may change their mind on what is to be done. 3. Write down your instructions. Paralegal Jamie Collins has frequently supervised and trained other paralegals and clerical staff. I cannot tell you, says Jamie, how many people I have trained that would come back to ask me a question and never write down a thing, only to return to my office a few moments or hours later or the next day with the exact same question and no clue how to answer it. Never go to your supervisor without pen and paper. or some means to make a record of the instructions provided. Whether through paper or electronically, keep an instructions notebook, diary, or journal in which you record the following information: notes on what you are asked to do, whether the tasks in the assignment are billable, important example, whether a particular client will be asked to pay fees for the performance of those tasks, the date you received the assignment, the date by which the supervisor expects you to complete all or part of the assignment. If an exact due date is provided, an estimate of the amount of time the task should take, sometimes referred to as a time budget, the date you actually complete the assignment, comments made by supervisors or others on what you submit. If no one makes comments, take the initiative and ask for feedback. The notes will serve as your memory bank. Whenever any questions arise about what you were supposed to do, you have something concrete to refer to. Exhibit A contains an assignment checklist on which you can record this kind of data for every major assignment you receive. In today's world, a supervisor's instructions may not be verbal, but through an email or other electronic means, as you would seek clarification verbally, seek clarification if the written instructions are not clear as well. The supervisor knows what they want and assumes they are being clear because they know what they want. This may not be the case, however. Ask questions. Keep asking questions until the assignment is clear. You do not want to work on an assignment, complete it, and submit it to then find out that you did not correctly understand the instructions. Ask questions. Exhibit A, checklist for major assignments. Name of supervisor for the assignment, what you have been asked to do, identification of the client or matter, specific areas or tasks, format supervisor expects, important example, computer text, final copy, date you are given the assignment, expected due date, time budget, the amount of time the task should take. Is the task billable to a client? If so, to what account, and the number of hours to spend on the assignment. Location of samples or models. Four, ask for a due date and a statement of priorities. You need to know when an assignment is due. What's the time budget? Ask for a due date Even if the supervisor tells you to get to it when you can, this phrase may mean relatively soon or before the end of the month to your supervisor, but not to you. If the supervisor says they do not know when it should be done, ask for an approximate due date. Tell the supervisor you want to place the assignment on your calendar so that it can be completed in a timely manner along with all your other assignments. Ask what priority the assignment has. Where does it fit in with your other assignments? If you have more than enough to fill the day, you need to know what takes priority. If you do not ask for a priority listing, the supervisor may assume you are under no time pressures. If you have assignments from different supervisors, gently suggest that the supervisors confer and let you know what the priorities are. Be sure you are communicating with your supervisor. That means do not make any assumptions about priorities and due dates. Ask. Five, if the instructions appear to be complicated, ask your supervisor to identify the sequence of tasks involved. As you receive instructions, you may sometimes feel overwhelmed by all that is being asked of you. Many supervisors do not give instructions in clear, logical patterns. They may talk in a rambling stream of consciousness fashion. When confronted with this situation, simply say, "Okay, but can you break that down for me a little more so that I know what you want me to do first? It would help if I approach it one step at a time. Where do you want me to start?" At the end of the verbal instructions, send a confirmatory email that sets forth your understanding of the assignment. If it is incorrect, your supervisor will clarify the instructions. Six, as often as possible, write your instructions in what you do in the form of checklists. A methodical mind is one that views a project in doable steps and that tackles one step at a time. A methodical mind is one that views a project in doable steps and that tackles one step at a time. You need to be methodical in order to function in a busy law office. One of the best ways to develop such a mindset is to think in terms of checklists. Attorneys love checklists. A great deal of the practice material published by bar associations, for example, consists of page after page of detailed checklists of things to do and or to consider when completing a project for a client. Attorneys want to be thorough. An unwritten rule of law practice seems to be that you cannot be thorough without a checklist. A checklist is simply a chronological sequence of tasks that must be done in order to complete an assignment. Convert the instructions from your supervisor into checklists. In the process of actually carrying out instructions, you go through many steps, all of which could become part of a detailed checklist. The steps you went through to complete the task become a checklist of things to do in order to complete such a task in the future. To be sure, it can be time-consuming to draft checklists. Keep the following in mind. The checklists will be a benefit to you in organizing your own time and in assuring completeness. The checklists can be invaluable for other employees who are given similar assignments in the future. Your supervisors will probably be very impressed by your initiative and organizational ability. You will not be able to draft checklists for everything that you do. Perhaps you will not be able to write more than one checklist a week. Perhaps you will have to use some of your own time to write checklists. Whatever time you devote will be profitability spent so long as you are serious about writing and using the checklists. They may have to be rewritten or modified later. This should not deter you from the task. Most things are worth doing require testing and reassessment. Here is how one veteran paralegal describes the process. When you are doing a multi-step task, thinking out each step as you move through it, create a checklist that will help you do it faster next time. Also, create a notebook to store it in so that when the job comes around again, you can find it. This is trickier to do on a busy day than you may think, but well worth doing. Think of these checklists as expanding your professional options. In time, they may become resources for training you give to newer paralegals. Many how-to manuals found in law offices were created out of the checklists that workers compiled on tasks they frequently performed. 7. Find out what practice guides and checklists already exist in your office. If practice guides and checklists on the topic of your assignment already exist in your office, you should find and use them. Also, check in computer databases where the office may store frequently used forms and instructions. Unfortunately, the how to do it information may be buried in the heads of the attorneys, paralegals, and secretaries in the office. No one may have taken the time to write it all down. If this is not so, find out where it is written down and try to adapt what you find to the assignment on which you are working. 8. Ask for a model. One of the best ways to make sure you know what a supervisor wants is to ask whether they know of any models that you could use as a guide for what you are being asked to do. Such models may be found in closed case files, manuals, form books, and practice texts. They may also be available online. Caution is needed whenever using models. Every new legal problem is potentially unique. What will work in one case may not work in another. A model is a guide, a starting point, and nothing more. Changes in the model will often be needed in order to adapt it to the particular facts of your assignment. Whenever you find a possible model your supervisor has not seen, bring it to their attention and ask whether it can be adapted and used. See Chapter 14 on how to avoid abusing standard forms. 9. Do some independent legal research on the instructions you are given. Often, you will be told what to do without being given more than a cursory explanation of why it needs to be done that way. Most instructions for legal tasks are based upon the requirements of the law. A complaint, for example, is served on an opposing party in a designated way because the law has imposed rules on how such service is to be made. You may be asked to serve a complaint in a certain way without being told what section of the state code or of your court rules requires it to be served in that way. It would be highly impractical to read all the law that is the foundation for an assigned task. It is not necessary to do so, and you would not have time to do so. What you can occasionally do, however, is focus on selected instructions for an assignment and do some background legal research to gain a greater appreciation for why the instructions were necessary. See the checklist on doing background legal research in Chapter 9. You will probably have to do such legal research on your own time unless the assignment you are given includes doing some legal research. Research can be time-consuming, but you will find it enormously educational. It can place a totally new perspective on the assignment and, indeed, on your entire job. 10. Get on routing and mailing lists for new legal material. A law office sometimes subscribes to publications for its in-house law library, whether in electronic form or traditional paper version, that are relevant to its practice. State bar journals are a good example of these types of publications. The publications can include legal treatises, and legal periodicals. Before these publications are saved electronically or shelved in the library, they are often routed to the attorneys in the office so that they can become acquainted with current legal writing that will be available in the library. Each attorney usually keeps the publication for a few hours or a few days for review before passing it on to the next person on the mailing list. If the actual publication is not passed around in this matter, those on the mailing list might receive brief summaries of recent publications or photocopies of their tables of contents. Another option in some offices is the use of email to inform attorneys of new publications. Ask to be included on these routing or mailing lists. The publications are often excellent self-education opportunities, particularly the articles in legal periodicals. You can also subscribe to free alerts on your area of practice. Find Law, www.findlaw.com, allows you to subscribe to free newsletters that give summaries of recent cases in designated areas of law. Newsletters.findlaw.com. For example, one of the areas covered by the newsletters is family law. If your office practices in this area, you should consider subscribing. Other online newsletters or alerts that may be helpful are the publications from the federal, state, and local courts. Recent decisions are usually noted in these publications and are often in the form of alerts or blogs. Subscribing to these court sites is invaluable. 11. Ask secretaries, executive assistants, and other paralegals for help. Secretaries, executive assistants, and paralegals who have worked in the office for a long time can be very helpful to you if you approach them properly. Everybody wants to feel important. Everybody wants to be respected. When someone asks for something in a way that gives the impression they are entitled to what is being sought, difficulties usually result. Think of how you would like to be approached if you were in the position of the secretary, executive assistant, or paralegal. What behavior or attitude of another employee would be off-putting? What would make you want to go out of your way to cooperate with and assist a new employee who needs your help? Your answers and sensitivity to questions such as these will go a long way toward enabling you to draw on the experience of others in the office. The simple approach is to be professional and courteous. That always goes a long way in any office setting. Obtain feedback. 12. Obtain feedback on an assignment before the date it is due. Unless the assignment you are given is a very simple one, do not wait until the date it is due to communicate with your supervisor. If you are having trouble with the assignment, you will want to check with your supervisor as soon as possible and as often as necessary. It would be a mistake, however, to contact the supervisor only when trouble arises. Of course, you want to avoid wasting anyone's time, including your own. You should limit your contacts with a busy supervisor to essential matters. You could take the following approach with your supervisor. Everything seems to be going fine on the project you gave me. I expect to have it in to you on time. I'm wondering, however, if you could give me a few moments of your time. I want to bring you up to date on where I am so that you can let me know if I am on the right track. Perhaps this contact could take place on the phone, email, or during a brief office visit. Suppose that you have gone astray on the assignment without knowing it. It is obviously better to discover this before the date the assignment is due. The more communication you have with your supervisor, the more likely it is that you will catch such errors before a great deal of time is wasted. Now back to our fact pattern at the beginning of the section. How would you now manage your approach? You know that you need to prepare a digest for existing depositions. Based on this section, you may want to approach one of the paralegals in the meeting and introduce yourself. Explain that it is your first day and would appreciate some guidance from them. Most staff will welcome your inquiry. It shows that you want to properly prepare for the assignment and determine what is the best approach to use based on past firm cases. Chances are that you will be given models and examples of deposition digests from other firm cases. Check with the paralegal on the due date and then confirm that information with your supervisor. You may even ask the more experienced paralegal to check your progress to ensure you are on the right track. Don't be afraid to ask questions. It is expected. Now you are on your way to becoming a paralegal and putting all that studying into real-life practice. Ask to participate in office and community training programs. Sometimes a law office conducts training sessions for its attorneys. Ask if you can be included. Bar associations and paralegal associations often conduct sessions on legal topics relevant to your work. They are part of what is called continuing legal education, CLE. Seek permission to attend some of these sessions if they are held during work hours. If they are conducted after hours, invest some of your own time to attend. Also, check into what is available online. Because of the COVID-19 pandemic, online CLE has become increasingly popular and necessary because you can take courses at any time and in any location where you have access to the internet. Your employer may be willing to pay all or a part of the cost of such courses. Some organizations offer scholarships for CLE. Always investigate that possibility. However, even if you must pay the cost, it will be a worthwhile long-term investment. 14. Ask to be evaluated regularly. When you first interview for a paralegal position, Inquire about the policy of the Office on Evaluations. Are they conducted on a regular basis? Are they done in writing? Will you know in advance the specific criteria that will be used to evaluate your performance? If you are hired in an office that does not have a formal evaluation structure or procedure, take the initiative to let supervisors know that you consider evaluations to be important to your professional development. It may take a while for you to feel confident enough to make this known, but the importance of doing so cannot be overestimated. For a number of reasons, many offices do not have formal evaluations. Evaluations can be time-consuming. Evaluators are reluctant to say anything negative, especially in writing. Most of us do not like to be evaluated. It's threatening to our ego. Go out of your way to let your supervisor know that you want to be evaluated and that you can handle criticism. Consider this approach that a paralegal might take with a supervisor. I want to know what you think of my work. I want to know where you think I need improvement. That's the only way I'm going to learn. I also want to know when I'm doing things correctly, but I'm mainly interested in your suggestions on what I can do to increase my skills. If you take this approach and mean it, the chances are good that you will receive constructive criticism and gain a reputation for professionalism. 15. Proceed one step at a time. Perhaps the most important advice you can receive in studying law in school and on the job is to concentrate on what is immediately before you. Proceed one step at a time. What are your responsibilities in the next 15 minutes? Block everything else out. Make the now as productive as you can. Your biggest enemy is worry about the future. Worry about the exams ahead of you. Worry about your family. Worry about the state of the world. Worry about finding employment, etc. Leave tomorrow alone. Worrying about it will only interfere with your ability to make the most out of what you must do now. Your development in the law will come slowly, in stages. Map out these stages in very small time blocks, beginning with the time that is immediately ahead of you. If you must worry, limit your concern to how to make the next 15 minutes shine. Chapter Review. Summary. Getting started. Classroom learning. A. Legal education is a lifelong endeavor. A paralegal never stops learning about the law and the skills of applying it. Important to this concept is learning the rules that apply in a particular situation. Learning what rules to apply will enhance your skills both in the classroom and the job setting. Critical to any study of the law is knowing that it is different than what you see on TV or in a movie. B. To avoid studying in a vacuum, know the goals and context of an assignment. Organize your day around a study plan. Engage in active studying, such as writing down new word definitions or creating charts and mnemonics. Assess your study habits, such as how you handle distractions or how you commit things to memory. C. Increase your proficiency in the basics of writing. Review rules of grammar and find tests online. Relearn the rules, such as the rules about the commas or when to use that rather than which in your sentences. D. You have entered a field where the written word is paramount. Grammar, spelling, and composition skills may need to be remastered. Do not rely on word processing programs to correct your spelling or grammar. They miss things. E. Forming a study group is helpful as a learning tool. This will assist in learning the law and bouncing ideas around with it. This will assist in learning the law and bouncing ideas around with the group. Share notes and information. F. An important component of studying is note-taking. Learn to take good notes by learning how to listen and determine what is important. Always review your notes after class and fill in any gaps from the lectures. Use abbreviations for faster and more efficient note-taking. Determining how you best learn through memory is essential. Assess how you learn. Reread assigned material. Highlight and write notes in the margins of the books or in a notebook. This helps with memory retention. Rewrite words and definitions. Have someone ask you questions about the material and verbally respond. Find the methods that work for you style of learning. Read to maximize your retention levels. On-the-job learning, the art of being supervised. A. Once you are on the job, always be sure you understand the tasks you are being asked. Ask questions and seek clarity from your supervisor. Don't pretend you understand what you don't. This could delay the proper completion of the assigned task. B. Repeat instructions back to your supervisor before you begin an assignment. Ask for due dates. Ask for priorities if you are given several things to do. Write down your instructions in your own notebook or journal. If questions arise once the assignment begins, ask questions by email or in person. Do not wait until the due date to seek clarification. C. Become an avid user of checklists. Include those you create on your own. Find out if an assignment has been done by others in the past. If so, Seek their help. Try to find a model and adapt it as needed. Be prepared to do some independent research. D. Ask your supervisor if you can be on internal office mailing lists for new publications. Also, find out what's available online to keep current in your area of the law. Participate in training programs at the law office and in the legal community. E. Ask to be evaluated regularly. Seek feedback before an assignment is due. This will assist you in knowing your strengths and weaknesses, including the areas that need additional attention. Chapter Review. Review questions. 1. Why must a student of law be a perpetual student? 2. How do you design a study plan? 3. What are some of the techniques of active studying? 4. What steps can you take on your own to increase your proficiency in grammar, spelling, and composition? 5. What danger do you need to be aware of when using computer spell checkers? 6. How can legal research help you handle difficult aspects of any course? 7. Why is note-taking important in the study and practice of law? 8. What are some of the steps you can take to increase your powers of retention? 9. Where and how can you obtain feedback on your schoolwork? What are the major techniques of receiving instructions from your supervisor on assignments? 11. Why is it important to obtain a specific due date and a statement of priorities for assignments? 12. How can you translate instructions into checklists? 13. How can you obtain help on an office assignment from practice guides, manuals, models, independent legal research, secretaries, and other paralegals? 14. Why is continuing legal education, CLE, and in-office training an important aspect of your legal education and legal training? 15. How can you obtain feedback on an assignment from a busy supervisor? Chapter Review. Assignments. 1. Prepare a list of techniques used to assist in establishing and enhancing your study habits. 2. As you begin each chapter of this textbook, create a study plan that will integrate the skills discussed in this chapter. Be sure to periodically revisit the plan to edit or change it based on your needs. 3. Create a checklist to have an effective working relationship with your supervisor. Update the checklist as needed. Part 1. The paralegal in the system. Chapter 1: Introduction to the Paralegal Career. Chapter Introduction. Chapter Objectives. After completing this chapter, you should be able to describe the importance of precision in the practice of law, list the major organizations for paralegals and the roles that they play, explain the major classifications of paralegal titles, summarize the different components of the definition of a paralegal, outline the major categories of fees, illustrate the importance of Missouri v. Jenkins in the advancement of paralegalism, identify the major employers that have career ladders for paralegals, identify the factors that determine a paralegal's salary, explain why the personal reputation of an individual is important in the use of social media and how to build a positive online presence. Summarize the factors influencing and contributing to the growth of paralegalism in the legal profession. What if you have started a new job at a small law firm? You've been there for about 3 months. All your friends and family know that you are working at a law firm and are really proud. That's all they can talk about at a family gathering. Aunt Mary pulls you aside and tells you that your cousin Chris was just evicted from his apartment. She was going on and on about him not paying rent because the place was infested with cockroaches. 30 days and he will be out. No one knows what to do. Of course, she knows that you are now studying to be a paralegal and persists in asking for legal advice. They can't afford a lawyer and want you to help with the filings with the court. You politely tell Aunt Mary that you are not a lawyer and don't know the first thing about evictions. You tell her that you can ask around about lawyers who know how to defend an eviction. Aunt Mary starts to cry because they can't afford a lawyer, and she knows you can help. Isn't that what you are studying? You feel bad and decide the best way to handle your aunt is to tell her that you will think about it. You escape and decide that it's time to go home before another family member approaches with another legal problem. Don't they know you are not going to law school and can't give legal advice? Family? Fact scenarios such as this are common for anyone associated with the legal profession. Whether you are at a party, out with friends, or shopping, the moment someone finds out you have a legal background, there is always someone they know who has a legal problem, and they want free advice. As you will learn as you embark on your legal career, it is a hazard of the profession, but you also will learn how to handle the issue adroitly and professionally. This is the focus of this chapter. What exactly is a paralegal? What are your responsibilities as a paralegal? What you can and cannot do as a paralegal, and what the guidelines are for charging fees for a paralegal services. Let's find out. 1-1. Launching your career. Welcome to the field. You probably fall into one or more of the following categories. You have never worked in a law office. You are or once were employed in a law office and now want to upgrade your skills. You want to explore the variety of careers in law for which a paralegal education can be a point of entry. As you begin your legal education, you may have many questions. What is a paralegal? Where do paralegals work? What are the functions of a paralegal? How do I obtain a job? How do attorneys and paralegals work together as a team? What is the difference between a paralegal and the clerical staff of a law office? How do new paralegals adjust to the realities of a law practice? How is the paralegal field regulated? Who does the regulating and for what purposes? What are the ethical guidelines that govern paralegal conduct? What career options are available once a paralegal has obtained experience? It is an exciting time to be working in the law. So many aspects of our everyday lives have legal dimensions. The law plays a dominant role in a spectrum of issues that range from the status of the sale of cannabis to the termination of life support systems. The number of cases filed every year in state and federal courts is staggering. Whether we like it or not, many of us will need the advice of an attorney at some point in our lives. Not surprisingly, U.S. corporations have had one or more lawsuits filed against them in the past 12 months and are managing on average dozens at any given time. The news media are preoccupied with laws that have been broken, laws that no longer make sense, and laws that ought to be passed to create a more just society. Caught up in the whirlwind of these debates is the attorney and the attorney's team, a prominent member of which is the paralegal. A prominent paralegal was once asked why she became a paralegal. Deep down, she said, a good number of us entered the profession because legal proceedings touch everyone on a very personal basis several times during a lifetime. So it is a profession that everyone can relate to. As a paralegal, you also gain the satisfaction of knowing you were able to help solve a problem for a client. There are other satisfactions as well. Once you have completed your paralegal education, and gained experience on the job, you can explore a variety of career options within traditional paralegal employment settings. In addition, an experienced corporate paralegal in a law firm might leave the firm to take a higher paying position as a securities analyst for a corporation. An experienced estates paralegal at a law firm might leave for a more lucrative position as a trust administrator at a bank. Once you gain the education, there are so many avenues that can be pursued with a paralegal degree or certification, such as political office, government service, or nonprofit work, to name a few. The value and versatility of legal education cannot be underscored enough. 1-2. Do you know what time it is? Precision matters. Perhaps you are wondering what working in the law will be like. One of the hallmarks of legal work is its diversity. In 5 years, if you meet a fellow classmate and compare notes on what your work days are like as paralegals, you'll see similarities, but you will probably be startled by the differences. One way to gauge what working in a law office or other related areas might be like is to answer a particular question. Stop what you are doing for a moment and answer this question. Did you know what time it is? Depending on when you are reading this book, you will probably look at your watch or the clock on the cell phone and answer 9:45 a.m., 1:30 p.m., 3:32 p.m., 11:28 p.m., etc. There could be hundreds of possible answers, but if you answered in this manner, you've made your first mistake in the study and practice of law. Look at the question again. Read it slowly. You were not asked, what time is it? You were asked, do you know what time it is? There are only 2 possible answers to this question: yes or no. Welcome to the law. One of the singular characteristics of the field you are about to enter is its precision and attention to detail. Vast amounts of time can be wasted by answering the wrong question. In fact, attorneys will tell you that one of the most important skills in the law is the ability to identify and focus on the question, the issue that must be resolved. Developing this sensitivity begins with the skill of listening very carefully. It also involves thinking before responding, noting distinctions, noting what is said and what is not said, being aware of differences in emphasis, and being aware that slight differences in the facts can lead to dramatically different conclusions. Even relatively minor variations in punctuation can sometimes have legal consequences. Compare, for example, the following two statements and note the dramatic difference in meaning that results from the placement of commas. Johnson said the officer hid the evidence. Johnson said the officer hid the evidence. In 2008, Chief Justice of the United States, John Roberts, administered the presidential oath of office by having Barack Obama solemnly swear that I will execute the office of President of the United States faithfully. But the Constitution states that the adverb faithfully should go before the verb that it modifies. Solemnly swear that I will faithfully execute the office of the President of the United States. After the inauguration ceremony, the Chief Justice returned and administered the oath again, this time by the book. The hallmark of a professional is precision in language and the ability to identify what is different or unique about a particular person or situation. In this sense, highly competent paralegals are true professionals. Another major characteristic of law is its focus on definitions and intentions. Attorneys are preoccupied with questions such as, what definition did the legislature intend? And what does the clause mean? For example, if a will says, I give $30,000 to my 3 children, Bill, Grace, and Sam, does each child receive $30,000, or is this amount to be split among the 3 children so that each receives $10,000? The answer depends on the intent of the deceased when the will was written. On September 11th, 2001, when 2 airplanes struck the 2 towers of the World Trade Center 16 minutes apart, was the landlord of the towers entitled to one insurance payment of $3.5 billion or 2 payments totaling $7 billion? The answer turned on the definition of the word occurrence in the insurance contracts. Was there 1 attack, 1 occurrence, or 2? After extensive litigation, the landlord was not successful in convincing the courts that there were 2 occurrences under all of the insurance contracts involved in the case. In a discussion on LinkedIn, the social network for professionals, paralegals, were asked about the career they had chosen. Here are some of the responses. I'm constantly intellectually stimulated and have made amazing friends. I have been with the same firm for 17 years, longer than any of my romantic relationships, and still have days when my heart beats faster and am excited about something I am doing, usually digging up hard-to-find information, helping a client get much-needed benefits, learning new technology, or writing substantive content. Each day brings something new. If you let it be known that you are looking for a challenge, you will certainly find it in this career field. Not every case in a law office makes the headlines, and not every paralegal is satisfied with all aspects of their job. Yet the potential is there for a paralegal career to provide substantial fulfillment and a broad range of opportunities. In short, you have a great deal ahead of you in the study of law. It's going to be a fascinating adventure. One 3. The scope of your legal education. Legal education is a very broad area of study. You will be covering a great deal of material in your courses. Will you use all of this material on the job? Not necessarily. Yet the material must be covered in order to comprehend the legal system and the world of attorneys. For example, you will learn about appellate briefs and sophisticated legal research, even though many paralegals never draft such briefs nor perform such research. Yet you need to have a basic understanding of such tasks in order to communicate with attorneys and to perform assignments related to these tasks. In short, understanding the role of a paralegal requires an understanding of and exposure to a wide range of paralegal and attorney skills as you begin the journey of comprehending the practice of law and the legal system as a whole. Areas that are essential to the performance of specific paralegal tasks include the functions of courts, legislators, and administrative agencies, the rules of professional responsibility, ethics, governing attorneys and paralegals, the rules of grammar and clear communication, the ability to state facts accurately and comprehensively, the basics of computer hardware and software on your desk and in the cloud, the ability to adapt to the different standards of different attorneys in an environment where time pressures can be intense. Without a grasp of these essentials, a paralegal career can flounder. Hence, we will spend a good deal of time on them, yet we will also cover the big picture, which includes tasks that many attorneys never assign paralegals to perform. This broader perspective is needed to develop into a well-rounded paralegal and to be ready for the great diversity that awaits you within the legal community. One 4. Major players. Organizations for paralegals. During this course, we will be introduced to many organizations. Here is an overview of some of the major players, not necessarily listed in order of influence. American Bar Association Standing Committee on Paralegals, SCOP. The Association for Legal Support Professionals, NALS. National Association of Legal Assistants, NALA. National Federation of Paralegal Associations, NFPA. Your State Bar Association, see Appendix A. Your local paralegal association, See Appendix A. These organizations are covered in some detail throughout the remaining chapters of the book, but a brief word about each will be helpful at this point. All 6 organizations extensively promote and most offer continuing legal education, CLE, which is training in the law, usually short-term, that a person receives after completing their formal legal training or after becoming employed. (1-4A) National Federation of Paralegal Associations, NFPA, www.paralegals.org. NFPA was established as a national paralegal organization in 1974. NFPA is an association of more than 50 state and local paralegal associations throughout the country. See Appendix A. Individual paralegals can also be members, but most are connected to NFPA through their local paralegal association. More than 9,000 paralegals are part of the NFPA network. NFPA offers voluntary certification for entry-level paralegals, PCCE, Paralegal Core Competency Exam. By entry-level, we mean that the certification credential can be earned without having paralegal job experience. In the job market, entry-level also refers to a starting position for someone with little or no experience. NFPA has another voluntary certification program for paralegals with experience, PACE, Paralegal Advanced Competency Exam. We discussed these credentials in Chapter 4. 1-4B, National Association of Legal Assistants, NALA, www.nala.org. NALA is primarily an association of individual paralegals, although 81 state and local paralegal associations are affiliated with NALA. See Appendix A. More than 15,000 paralegals in the country are represented by NALA. It offers voluntary certification for entry-level paralegals, CLA/CP, Certified Legal Assistant /Certified Paralegal, and for paralegals with experience, APC, Advanced Paralegal Certification. See Chapter 4. 1-4C, NALS, the Association for Legal Support Professional, www.nals.org. The oldest national association in the country is NALS, the Association for Legal Support Professionals. See Appendix A. The association consists of more than 4,000 paralegals and legal secretaries in 100+ chapters throughout the country. NALS offers a voluntary certification examination, PP, Professional Paralegal. See Chapter 4. NALA was initially formed as a breakaway association from NALS. Both associations are still headquartered in Tulsa, Oklahoma. At one time, NALS stood for National Association of Legal Secretaries. The organization kept the abbreviation but changed its meaning. (1-4D) American Bar Association Standing Committee on Paralegals, SCOP. www.americanbar.org/groups/paralegals.html. The American Bar Association, ABA, is a voluntary association of attorneys. No attorney must be a member, yet it is a powerful organization because of its resources, its prestige, and the large number of attorneys who have joined. The ABA has a standing committee on paralegals, SCOP, that has had a significant impact on the growth of the field. The role of the ABA has included the publication of research on paralegals, the establishment of a voluntary program of approving paralegal schools, and the creation of an associate membership category for paralegals. (1-4E) State Bar Association of your state. Most state bar associations have been active regarding the role of paralegals in the practice of law. Many of the associations have issued 1. Guidelines on the proper use of paralegals by attorneys, and 2. Ethical opinions that apply the state's ethics code to an attorney's use of paralegals. We examine such guidelines and opinions in Chapter 6 and in Appendix C. Some state bar associations have followed the lead of the ABA and allow paralegals to become associate or affiliate members. See Exhibit 1-1 for a summary of the national paralegal organizations. Exhibit 1-1 Summary of the national paralegal organizations. National paralegal organizations. National Federation of Paralegal Associations, NFPA. National Association of Legal Assistants, NALA. Association of Legal Support Professionals, NALS. (1-4F) Your legal paralegal association. See Appendix A. Paralegal associations fall into at least 14 categories, some of which overlap. 1. Nationwide. Important example, NFPA, NALA, NALS. Statewide. Important example, Illinois Paralegal Association. Region-wide. Encompassing more than one state. Important example, Rocky Mountain Paralegal Association. 4. Region-wide within a state. Important example, South Florida Paralegal Association. 5. Countrywide. Important example, Santa Clara County Paralegal Association. 6. Citywide. Important example, New York City Paralegal Association. 7. Practice specific. Important example, Houston Corporate Paralegal Association. 8. Division of a bar association. Important example, Paralegal Division of the State Bar of Texas. 9. Association of Associations. Important example, Empire State Alliance of Paralegal Associations. 10. School-wide. Important example, Fresno City College Paralegal Association. 11. Manager-focused. Important example, International Practice Management Association. 12. Association whose membership is limited to paralegals. Important example, Orange County Paralegal Association. 13. Association whose membership consists of paralegals, legal secretaries, and other non-attorneys. Important example, NALS. 14. Foreign. Important example, Canadian Paralegal Association. Most paralegals in the country have joined a state, regional, county, city, or bar-affiliated paralegal association. They are collectively referred to in this book as local paralegal associations. Through CLE and networking, a great many paralegals have found major career support and inspiration by active participation in their local paralegal association. If any of them have a student membership rate, you should consider joining now while you are in this course. Social media and paralegal organizations. A good way to stay updated and connected to what's going on in your profession is to follow several of the paralegal organizations on social media. If you are not already social media savvy, try setting up a Facebook or X, formerly known as Twitter, account and follow a national or local paralegal organization as a way of getting involved and learning more about the paralegal profession. Continuing legal education, CLE, courses are often advertised, as well as upcoming conferences where networking opportunities are presented. Job opportunities are noted as well. LinkedIn is another social media site that will open professional doors for jobs and connecting with other paralegal professionals. Social media sites are a way to introduce yourself to the profession and have the profession introduce itself to you. Another helpful social media site that can provide invaluable information, especially in the educational area, is YouTube. Organizations such as NFPA, NALA, and NALS post a variety of informational videos on professional development, ethics, and a myriad of other topics that are important to your paralegal journey. Many of the local, regional, and state paralegal associations have a major social media presence on many of these sites mentioned. Seek out the information and become an active participant in the profession while you are getting your paralegal education and training. One 4G. Other important organizations. Although NFPA, NALA, NALS, SCOP, your State Bar Association, and your Paralegal Association will dominate our discussion of paralegalism, we will also be referring to other important groups, such as the following: International Practice Management Association, IPMA, an association of paralegal supervisors in large offices, www.paralegalmanagement.org. American Association for Paralegal Education, AAFPE, an association of paralegal schools, www.aafpe.org. Association of Legal Administrators, ALA, an association of individuals, mostly non-attorneys, who help administer or manage law offices, www.alanet.org. American Alliance of Paralegals, Incorporated, AAPI, a national association of paralegals that offers certification without an examination, www.aapipara.org. Online exercise. Determine your state and local paralegal associations. Write down the website and see if they have a newsletter or blog that you can subscribe to. 1-5, job titles. What's in a name? 1-5A, paralegal and legal assistant. For convenience, this book uses the title paralegal. At one time, another common title was legal assistant. For years, most people agreed that these titles were synonymous, just as the titles attorney and lawyer are synonymous. Yet the titles paralegal and legal assistant have been the source of confusion and debate. For example, in some state governments, legal assistant positions are attorney positions. In federal government, most legal secretaries are called legal assistants. More significantly, many private law offices have changed the title of their legal secretaries to legal assistants without changing the requirements for their position or the duties they perform. Those who favor this title change say that it reflects the broader role that many secretaries perform. Cynics, however, argue that the change is due to the fact that the courts can give attorneys separate fees for the work of their legal assistants, but not for that of their secretaries. We will be examining such fees later in this chapter. The shift in title from secretary to legal assistant has not been universal. There are still individuals called legal secretaries in offices throughout the country. Yet the number of legal secretaries, now called assistants, is substantial. And this has led many to conclude that the legal assistant and paralegal titles are no longer synonymous. There is an emerging preference for the paralegal title. For example, many local associations have voted to change their name from Legal Assistant Association to Paralegal Association. One of the largest paralegal organizations in the country, the Legal Assistant Division of the State Bar of Texas, changed its name to the Paralegal Division of the State Bar of Texas. As indicated, an important committee of the American Bar Association is the Standing Committee on Paralegals. Its former name was the Standing Committee on Legal Assistance. The National Association of Legal Assistants, NALA, however, is adamant that the terms legal assistant and paralegal are used interchangeably. This is also the view of the International Practice Management Association, IPMA. Yet, even IPMA has gone through a name change. It was once known as the Legal Assistant Management Association. NALA itself has acknowledged this trend. As we will see in Chapter 4, if you take and pass NALA's certification exam, you have a choice of being called a Certified Legal Assistant, CLA, or a Certified Paralegal, CP. The former title has been available since the 1970s. The latter was added as an option in 2004 and is now preferred by those who pass the exam. It is true that some laws discussed in Chapter 4 treat paralegals and legal assistants as synonyms. Yet, the momentum continues on many fronts to separate the positions of legal assistant and paralegal, and to prefer the latter. To summarize, at one time, everyone considered paralegal and legal assistant to be interchangeable titles. They were synonymous. Paralegal became the preferred title after many attorneys allowed their secretaries to be called legal assistants. Some laws and some organizations, however, still maintain that the titles are interchangeable. (1-5B) Other titles. This is not to say that paralegal and legal assistant are the only titles in the field. Far from it. Many other titles are in use. Several reasons account for this diversity. First, there are no national standards regulating the paralegal field. Every state is free to regulate or to refuse to regulate a particular occupation. Second, most states have not imposed the kind of regulation on paralegals that would lead to greater consistency on titles within a particular state. For example, most states have not imposed minimum educational requirements for licensing. Hence, few restrictions exist on who can call themselves paralegals, legal assistants, or related titles. Although there are some major exceptions in states such as California, South Dakota, and Maine that limit who can use specific titles discussed in Chapter 4. For the most part, there are no such restrictions. To begin sorting through the maze, we examine two broad categories of workers: those who are employees of attorneys, often called traditional paralegals, and those who are independent contractors. In general, independent contractors are self-employed people who operate their own business and contract to do work for others. In general, those who hire the services of independent contractors do not control many of the administrative details of how the services are performed. The objectives or end products of the services, however, are controlled by those who hire them. We will be examining two kinds of independent contractors in the legal field: those who sell their services to attorneys, a relatively small group, and those who sell their services to the public without attorney supervision, a larger and more controversial group. Within these two categories, you will find considerable diversity and overlap in the titles that are used. Before examining independent contractors, let's first look at traditional paralegals, those who are employees of attorneys. Employees of attorneys. The vast majority, over 95%, are employees of attorneys. They may be given the titles attorney's assistant, lawyer's aide, lawyer's assistant, legal analyst, legal assistant, legal paraprofessional, legal service assistant, legal technician, mid-level paralegal, the most common, paralegal and legal assistant, paralegal assistant, professional legal assistant. They are all traditional paralegals if they are employees of attorneys. Most are full-time employees. Some, however, are temporary employees who work part-time or who work full-time for a limited period when a law office needs temporary help, usually from paralegals with experience in a particular area of law. If a law firm has relatively large number of paralegals, it might assign its entry-level people with the following titles: assistant paralegal, case clerk, case handler, case technician, clerk and runner, docketing coordinator, document clerk, entry-level paralegal, intake paralegal, junior paralegal, legal assistant 1, legal assistant clerk, paralegal 1, paralegal case handler, paralegal clerk, project case management, project case assistant, project clerk. Large law offices may also have individuals who help recruit, train, and supervise all paralegals in the office. This supervisor might be given the following titles: Case Manager, Director of Legal Assistant Services, Director of Legal Assistance, Director of Paralegal Services, Director of Practice Support, Legal Assistant Administrator, Legal Assistant Coordinator, Legal Assistant Manager, Legal Assistant Supervisor, Legal Support and Professional Personnel Manager, Manager of Paralegal Services, Paralegal Administrator, Paralegal and Case Manager, Paralegal Coordinator, Paralegal Manager, Paralegal Supervisor, Senior Paralegal, Supervising Legal Assistant. As indicated earlier, these individuals have their own association, International Practice Management Association, IPMA. For more on entry-level and supervisory paralegals, see the discussion of career ladders later in this chapter. Analyze this. Survey some legal employers, such as law firms, attorney general offices, legal services, corporations, and nonprofits, and determine the various legal titles given to paralegals. All of the titles listed thus far are generic, in that they tell us little or nothing about the person's primary skills or area of the law in which they work. Other employee job titles are more specific. Bankruptcy paralegal, commercial real estate paralegal, corporate law analyst, corporate paralegal, court researcher and paralegal, debt recovery paralegal, demands specialist, docketing paralegal, elder care paralegal, family law paralegal, foreclosure title paralegal, government relations paralegal, health advocate, healthcare paralegal, international trade paralegal, legal advocate for day laborers, litigation paralegal, litigation practice support specialist, patent prosecution paralegal, personal injury paralegal, probate specialist, public finance paralegal, real estate paralegal, senior medical paralegal, tax paralegal. Other special categories include the following: e-discovery paralegal, a person who helps an office identify information stored in digital formats. Important example, emails and spreadsheets. That may have to be exchanged between the parties during the discovery stage of litigation prior to trial. Depot summarizer, a person who summarizes pre-trial testimony, particularly depositions, in which attorneys question potential witnesses outside the courtroom in preparation for trial. Compliance paralegal, a person who helps assure that clients are complying with regulations that govern insurance, finance, construction, and other regulated industries. Judicial assistant, a person who works for judges within the federal, state, or local court system. Conflicts specialist, also called conflicts analyst or conflicts researcher, a person who helps the office determine whether it should refrain from taking a case because of a conflict of interest with present or prior clients. See Chapter 6. Nurse paralegal, a nurse who has become a paralegal using their medical training to help personal injury, PI, attorneys locate and decipher medical records and perform other litigation tasks. Nurse paralegals are usually employees of law offices. When they function through their own independent businesses, they are often called legal nurse consultant, LNC, or, if certified, legal nurse consultant certified, LNCC. See the American Association of Legal Nurse Consultants, www.aalnc.org. Some law firms divide their paralegals into two broad categories: litigation and transactional. Litigation paralegals work on cases in litigation, particularly in the pretrial stages of litigation. A transactional paralegal provides assistance to attorneys with clients engaged in a large variety of transactions, such as entering contracts, incorporating a business, closing a real estate sale, or planning an estate. A few large law firms have positions called specialist, analyst, or consultant. These are non-attorneys who have a high degree of expertise in a particular area, such as immigration, pensions, medicine, accounting, or environmental regulation. Skilled paralegals are sometimes promoted into these positions. Occasionally, when an office wants its paralegal to perform more than one job, hybrid titles are used. For example, an office might call an employee a an administrative assistant and paralegal, a paralegal and investigator, a paralegal and legal secretary, a paralegal and librarian. In general, the smaller the law office, the more likely it is that an employee will be asked to play multiple roles, even if they do not have a hybrid title. For example, an employee of an office with one attorney, a sole practitioner, could be the paralegal, the bookkeeper, the librarian, the investigator, the secretary, and the receptionist. Perhaps the strangest, and thankfully the rarest, hybrid title you may see is attorney and paralegal. A California law firm placed an ad in a Los Angeles legal newspaper looking for an individual to work under this title. What's going on? The legal job market fluctuates. Depending on the state of the economy, jobs for attorneys might be abundant or scarce. In lean times, parts of the country could be flooded with unemployed attorneys, many of whom are recent law school graduates. Occasionally, these attorneys apply for paralegal jobs. Some law firms are willing to hire a desperate attorney at a paralegal's salary. Because the firm can charge clients a higher billing rate for an attorney's time than for a paralegal's time, most law firms, however, think it is unwise to hire an attorney for a paralegal's position. The two fields are separate employment categories. Firms know that the attorneys are not interested in careers as paralegals. Yet there will continue to be attorneys available for paralegal positions and law firms willing to hire them, particularly when the firms need temporary legal help. There is a small category of attorneys who frequently seek work as paralegals. An attorney who has been disbarred or suspended from the practice of law may try to continue working in a law office by taking a job as a paralegal until they can reapply for full admission. Such work is highly controversial because of the temptation to go beyond paralegal work and continue to practice law. Consequently, some states forbid disbarred or suspended attorneys from working as paralegals. In most states, however, it is allowed with restrictions, as we will see in Chapter 6. Let's examine the case of N. Bruce D. Friedberg, 144 NYS 3D 183 2021 WL 1259155 NY 2021, where an attorney was disciplined and later worked as a paralegal. The court made a number of important observations in the case. Order of the court, a case study. In R.E. Bruce D. Friedberg, Supreme Court Appellate Division, First Judicial Department, New York, 144 NYS 3D 183 2021 WL 1259155 NY 2021. The case of N.R.E. Bruce D. Friedberg presents an interesting lesson. Don't try and hide your status as an attorney by calling yourself a paralegal. The facts of Friedberg are straightforward. Friedberg and another attorney helped an already suspended attorney, Eric Gonchar, work in their firm under the guise of being a paralegal. Gonchar ultimately was disbarred. While suspended, Gonchar continued to advise clients and held himself out as attorney. Friedberg and another attorney continued to aid in the ruse that he was only acting as a paralegal. In New York, any activity related to the practice of law is prohibited. As the court observed, providing services, whether paralegal or clerical, to other members of a law firm is fraught with peril and risks running afoul of the prohibition against the unauthorized practice of law. Citing a number of cases, the court called these acts inviting ethical peril, with the inescapable conclusion that the attorneys in the firm aided and abetted a suspended attorney in the unauthorized practice of law. In turn, the attorneys suffered the same fate: suspension. Discussion questions. Locate a copy of N. Re. Bruce D. Friedberg. The case was based on a recommendation by a referee. What was the referee's recommendation, and was it accepted by the court? What facts were critical to the court's findings? Did the court sanction the attorneys who assisted Gonchar? If so, what were the sanctions and actions the court ordered against Friedberg and his associate attorney? What ethical lessons are learned from N. R.E. Bruce D. Friedberg? Self-employed individuals who sell their services to attorneys. Independent contractors who sell their services to attorneys perform many different kinds of tasks. For example, they might draft an estate tax return for a probate attorney, or digest, important example, summarize, pretrial documents for a litigation attorney. Most independents work out of a home office. Some do their work in the law offices of the attorneys for whom they work. Independents who operate entirely online, as opposed to going to the offices of attorneys who hire them, are called virtual assistants or virtual paralegals. An independent might work primarily for one law office, although most work for different offices around town. Even though independent contractors are not employees, the attorneys who use their services are still obligated to supervise what they do. In Chapter 6, we will study the ethical problem of supervising a non-employee. In addition, we will cover the conflict of interest danger that can exist when an independent contractor works for more than one attorney. There is no uniform title that these self-employed individuals use. Here are some examples: contract paralegal, freelance legal assistant, freelance paralegal, independent paralegal, the most common, legal technician. Technology update. The virtual paralegal, here to stay. Prior to the COVID-19 pandemic, most paralegals went to work in buildings and high-rises with all staff physically present. March of 2020 changed that when the pandemic wreaked havoc in the United States as well as around the world. Practices and systems we once accepted as the norm had to change or be adapted to address the physical lockdowns that affected nearly everyone. Law offices had to figure out how to continue to represent their clients without physically going to court or meeting with them in an office or conference room. Courts had to find ways to keep the dockets moving and serve the public without the physical presence. Working remotely has now become standard practice. Not only did we see the advent of virtual calls, but we saw more and more legal professionals functioning in a completely virtual environment. An environment that only a handful of legal professionals embraced previously. What the pandemic forced us all to recognize was that much of our work could be done anywhere without physically being in an office. Out of necessity, the virtual paralegal became more prominent. A virtual paralegal works off-site and prepares and drafts legal documents to assist attorneys in their cases. They are task-oriented and can work from anywhere in the world so long as there is internet connectivity. Not a new concept, the virtual paralegal filled in the gaps that off-site work created. But one of the main concerns for a virtual paralegal is the need, the general legal requirement for supervision by an attorney. Thus, regardless of where a virtual paralegal works, under most circumstances, attorney oversight has not changed. As horrendous as the pandemic was for all of us, one of the emerging and possible positive results was the realization that more could be done remotely with success and less reliance on the typical brick and mortar concept of practicing law. This created an opportunity for paralegals to grow an area of their profession and prove that the virtual paralegal is here to stay. Self-employed individuals serving the public. Finally, we examine those independent contractors who sell their services directly to the public. As a group, they are known as document service providers, DSPs. Non-attorneys who work without attorney supervision to provide legal document assistance to individuals who are representing themselves. DSPs do not work for attorneys. They may have special authorization to provide limited services, as when a statute allows them to assist clients in Social Security cases. To find out what titles they use in your area, try Googling such terms as paralegal, legal, divorce, and bankruptcy. Examples of DSP titles include the following: bankruptcy petition preparer, BPP, contract paralegal, independent paralegal, legal document assistant, LDA, legal document preparer, LDP, legal technician, paralegal. Controversy over DSPs has come from three main sources: some of their legal clients, some bar associations, and some traditional paralegals. A few disgruntled clients of DSPs have filed complaints against them that have resulted in state prosecution for the unauthorized practice of law, UPL. The organized bar has instigated similar UPL charges on the grounds that the public needs protection from DSPs, particularly those who lack formal training. The bar also complains that the public might be confused into thinking that anyone called paralegal or who uses the word legal in their title works for an attorney. An unstated reason for opposition from the bar is the unwelcome competition that DSPs give to some practicing attorneys. A significant number of traditional paralegals resent the use of the paralegal title by some DSPs who work directly for the public. Most traditional paralegals have been through a rigorous training program and are subject to close attorney supervision on the job. These traditional paralegals resent anyone from being able to use the paralegal title without similar training and supervision. In most states, the formidable opposition from these three sources has not put DSPs out of business. In fact, their numbers are growing, although most states allow them to call themselves paralegals. A few states have imposed title restrictions. In California, for example, DSPs cannot call themselves paralegals or legal assistants unless they work under attorney supervision. If a California attorney is not responsible for their work, they must call themselves legal document assistants, LDAs. If they provide landlord-tenant help, they must be called unlawful detainer assistants, UDAs. In Arizona, DSPs who help people with legal documents are called certified legal document preparers, CLDPs. At the federal level, even greater restrictions have been placed on individuals who provide bankruptcy assistance. In every state, they must be called bankruptcy petition preparers, BPPs. Later, in Chapter 4 and 6, we will more closely examine the controversy generated by DSPs, including proposals in some states to increase their role. Online exercise. Check your jurisdiction to determine whether it permits document service providers, DSPs, to operate in your state. (1-6) Definitions of a paralegal. The definition of a paralegal we will use in this book is a person who performs substantive legal tasks on behalf of others when those tasks are supervised by an attorney who would be required to perform the tasks if the office did not have a paralegal. Definitions have been written by American Association for Paralegal Education, American Bar Association, local bar associations, paralegal associations, state bar associations, state legislatures, and state courts. (1-6A) Definitions written by state legislatures and state courts. By far the most important definitions are those written by state legislatures and courts. Not every state has a definition written by its legislature or by its courts, but the number of states that have them is steadily growing. Here is an example of a definition enacted by the state legislature in Illinois. The definition is typical of the definitions used in many states. Paralegal means a person who is qualified through education, training, or work experience and is employed by a lawyer, law office, governmental agency, or other entity to work under the direction of an attorney in a capacity that involves the performance of substantive legal work that usually requires a sufficient knowledge of legal concepts and would be performed by the attorney in the absence of the paralegal. Such definitions are often interpreted to include independent contractors who sell their services to attorneys but are not employees of the attorneys. (1-6B) Definitions written by associations. Many bar associations, paralegal associations, and the main paralegal educators Association have adopted definitions that are similar in scope to the Illinois definition. The language of the American Bar Association's definition has been widely adopted, with or without modification, by the other associations. See Exhibit 1-2. Exhibit 1-2. Paralegal definitions written by associations. American Bar Association, ABA. American Bar Association. A legal assistant or paralegal is a person qualified by education, training, or work experience who is employed or retained by a lawyer, law office, corporation, government agency, or other entity, and who performs specifically delegated substantive legal work for which a lawyer is responsible. www.americanbar.org/groups/paralegals.html. NALS, the National Association of Legal Support Professionals. NALS has adopted the ABA definition. www.nala.org. American Association for Paralegal. American Association for Paralegal Education. Paralegals are persons who perform substantive and procedural legal work as authorized by law, which work in the absence of a paralegal would be performed by an attorney. Paralegals have knowledge of the law gained through education or education and work experience, which qualifies them to perform legal work. www.aafpe.org. American Alliance of Paralegals, Incorporated. AAPI. A paralegal is a person qualified by education, training, or work experience who performs specifically delegated substantive legal work for which a lawyer is ultimately responsible, or who is authorized by administrative, statutory, or court authority to perform substantive legal work. www.aapipara.org/position statements .htm. National Association of Legal Assistants, NALA. NALA has adopted the ABA definition www.nala.org. National Federation of Paralegal Associations. A paralegal and legal assistant is a person who qualified through education, training, or work experience to perform substantive legal work that requires knowledge of legal concepts and is customarily, but not exclusively, performed by a lawyer. This person may be retained or employed by a lawyer, law office, governmental agency, or other entity, or may be authorized by administrative, statutory, or court authority to perform this work. Substantive shall mean work requiring recognition, evaluation, organization, analysis, and communication of relevant facts and legal concepts. www.paralegals.org. One dash 6C. Characteristics of the definition. Three major characteristics are common to most definitions of a paralegal. A paralegal has acquired legal skills through education, training, or on-the-job experience, works under attorney supervision, performs substantive legal work that the attorney would have to perform if the office did not have a paralegal. Under the first characteristic, there are two ways that individuals acquire legal skills. 1, formal education or training programs, and 2, on-the-job training, OJT. When the paralegal field first came into existence, see discussion of history later in this chapter, most paralegals acquired their skills by OJT, on-the-job training. Today, most do so by completing formal programs. Under the second characteristic, paralegals work under attorney supervision. This covers the vast majority of paralegals in the country, including independent contractors who sell their services to and are supervised by attorneys but are not attorney employees. What about independent contractors who sell their services directly to the public without attorney supervision? As we have seen, some states, for an example, California, restrict the paralegal title to people who work under attorney supervision. The definition of a paralegal in such states would not include independent contractors who sell their services to the public without attorney supervision. This conclusion, however, is not universal. In many states, independent contractors can call themselves paralegals, even if they do not work under attorney supervision. Under the third characteristic, the two key themes are 1, the absence test and 2. Substantive legal work. We need to take a close look at each of these themes because they will be relevant to the question of whether attorneys can receive paralegal fees for the tasks performed by their paralegals. Absence test. The third characteristic states the absence test. Under this test, a task is a paralegal task if it must be performed by an attorney if the office does not have a paralegal. If a task is a paralegal task, it is not a clerical or secretarial task. 3 conditions must be met for a task to be classified as a paralegal task under the absence test. Most securities do not have these skills. Most secretaries do not have the skills to perform the task. Most paralegals have the skills to perform the task. An attorney would have to perform the task if the office did not have a paralegal, but did have a secretary. To demonstrate, examine the following 2 tasks. Task 1, writing a complaint. If the office did not have a paralegal, would an attorney have to perform this task? Yes. A complaint is the plaintiff's first court filing, pleading, that states a legal theory for suing, called a cause of action. Legal skills are required to draft even relatively uncomplicated complaints. In general, most experienced paralegals have these skills needed to draft such complaints. But most secretaries do not have such skills. Consequently, if the office did not have a paralegal, the attorney would have to draft the complaint. Therefore, this is a paralegal task. Task 2, typing a complaint. If the office did not have a paralegal, would an attorney have to perform this task? No. A secretary could type the complaint using a desk or laptop computer. Does not require legal skills. If the office had a secretary, an attorney would not have to type the complaint. The secretary could type it. Therefore, typing a complaint is generally considered a clerical or secretarial task, not a paralegal task. The absence test requires you to examine who could perform a task, not who actually performs it in a particular office. Attorneys who type their own complaints are still performing a clerical task. The question is whether the attorney would have to perform the task if the office had a secretary. but not a paralegal. Similarly, there are some veteran secretaries who are able to draft complaints. This does not mean that such secretaries are performing clerical tasks when they draft complaints. The task is a paralegal task, even if there are some secretaries who can perform it. The absence test requires you to focus on the skills of most secretaries and most paralegals. Substantive legal work, SLW. What is substantive legal work, SLW? There are two ways of answering this question. First, we can simply apply the absence test. If an attorney would have to perform a task because the office has no paralegals, then the task is SLW, substantive legal work. In other words, SLW is non-clerical work. Second, we can list specific tasks and say that all tasks, like those on the list, constitute SLW, substantive legal work. In Delaware, for example, a court said in McMacken v. McMacken 651 A.2D778, 780 DEL.FAM.CT 1993 that SLW, substantive legal work, includes but is not limited to such activities as A. Factual investigation, including locating and interviewing witnesses. B. Assistance with depositions, interrogations, and document production. C. Compilation of statistical and financial data. D. Checking legal citations. E. Correspondence with clients, opposing counsel, and courts. F. Preparing, reviewing, and answering petitions and other pleadings. Similarly, note the specificity in the following list from the State Bar of Texas. Substantive legal work includes, but is not limited to, the following. A. Conducting client interviews and maintaining general contact with the client. B. Locating and interviewing witnesses. C. Conducting investigations and statistical and documentary research. D. Drafting documents, correspondence, and pleadings. E. Summarizing depositions, interrogatories, and testimony. F. Attending executions of wills, real estate closings, depositions, court or administrative hearings, and trials with an attorney. Substantive legal work does not include clerical or administrative work, online exercise. Find out if your state has adopted a definition of paralegal. If so, keep a copy of the definition and place it in your portfolio binder. See end of chapter assignments. 1-7 Paralegal fees. 1-7A Introductor. The distinction between paralegal and clerical tasks is critical when discussing fees, particularly paralegal fees. Paralegals can be a revenue source, a profit center for a law firm because the firm can collect paralegal fees for paralegal work. A paralegal fee is a fee that an attorney can collect for the non-clerical tasks of the attorney's paralegal. The fee covers the paralegal's substantive legal work on behalf of the client. Paralegals themselves do not charge or receive these fees. They are paid to the law office that employs the paralegals. To place paralegal fees in context, 4 separate financial categories should be distinguished: fees, court costs, special expenses, and operating expenses. Attorney fees and paralegal fees. Fees are payments for the services provided by attorneys and paralegals, often calculated by the hour unless the client agrees to pay a set amount or percentage of whatever is recovered. The latter is a contingent fee. Hourly fees are paid regardless of who wins the case. Contingent fees are paid only if the case is won or satisfactorily settled. Other categories of fees are discussed in Chapter 5. Court costs. Court costs are charges or fees paid to and imposed by the court that are directly related to litigation in that court. An example is a court filing fee. Special expenses. Special expenses are charges incurred by a law office that are unique to the representation of a particular client. An example is the cost of hotel and travel when an attorney must conduct a trial in another city. Operating expenses. Operating expenses are charges incurred by the office in order to stay open and provide services to any and all clients. Examples include rent, insurance, and secretaries. Another name for operating expenses is overhead. Paralegals are not part of a firm's overhead. They are a source of income for the firm through paralegal fees, which can be substantial. Most clients pay the first three categories: attorney and paralegal fees, court costs, if any, and special expenses, if any. With limited exceptions, they do not pay for overhead. Clients do not receive a separate bill for their share of the electricity the office used while representing them. The law office is expected to pay for such overhead out of the fees it receives from all its clients. It is possible, however, for a client to agree to pay a separate fee for some secretarial help if the amount charged is reasonable. When the attorney-client relationship is formed, the attorney and client enter a fee agreement that specifies what fees and other payments will be the responsibility of the client. The agreement is called an attorney-client fee agreement or an engagement letter. There are two sources of attorney and paralegal fees. The main source is the attorney's own clients, which is the norm called the American rule in the United States, unless the case is taken on contingency. The client pays these fees whether or not the attorney wins the case. Some other countries follow the English rule, under which an opponent pays the fees of the winning side in litigation. Although we do not follow the English rule, there are three situations in which the losing side does pay the attorney and paralegal fees of the winning side. In these limited situations, we follow a version of the English rule. Paying the other side's fees is called fee shifting, which we will now examine. (1-7b) Fee shifting. The three situations in which fee shifting occurs in the United States are triggered by prior agreement, bad faith, and special statutes. Prior agreement. Parties can always agree to shift payment of fees and related costs. In a separation agreement, for example, the wealthier spouse might agree to pay the fees and costs of the other spouse. In many states, the divorce court has the power to order such a shift, even if the parties have not agreed to do so on their own. Also, in many consumer contracts, the parties might agree to a clause stating that the buyer of goods or services must pay the fees and costs of the seller if the seller sues the buyer for non-payment. Bad faith. Bad faith is dishonesty or abuse in one's purpose or conduct. Suppose, for example, that a court is convinced that a party has filed a frivolous motion solely to harass the opponent. The court, in such a case, might require the party making the frivolous motion to pay the fees and costs of the opponent who was forced to respond to the motion. Special statute. Congress and some state legislatures have passed special fee-shifting statutes to encourage aggrieved parties to bring litigation in certain areas of law. The purpose of such statutes is to support specific social or policy goals in areas such as civil rights, environmental protection, employment discrimination, antitrust conduct, and securities fraud. Under these statutes, attorney and paralegal fees and costs are paid by the defendant if the plaintiff is successful in the litigation. The cases in which such fee shifting can occur are called statutory fee cases. Without fee shifting, injured parties might not be able to bear the cost of seeking a remedy in which without fee shifting, injured parties might not be able to bear the cost of seeking a remedy in the courts. Hence, violations of civil rights, environmental laws, and the like would not be remedied. This is not good for society as a whole. Fee-shifting statutes, therefore, have been passed to encourage aggrieved parties to challenge such violations in court. In the first two categories of fee-shifting cases, prior agreement and bad faith, fees can be awarded regardless of who wins the case. In statutory fee cases, however, a party can be ordered to pay the fees of its opponent only if the opponent wins the case. In statutory fee cases, not all legislatures and courts use the same language in describing the relationship between attorney fees and paralegal fees. Sometimes paralegal fees are referred to as being part of attorney fees. At other times, attorney fees and paralegal fees are treated as separate entities. Regardless of how the relationship is phrased, the result is the same. A court can award two sets of fees. One for attorney work and another for paralegal work. A major reason paralegalism has blossomed as a profession is the ability of a law office to collect paralegal fees from its own clients in most cases, and from a losing opponent in statutory fee cases. Paralegal fees in statutory fee cases can be substantial. Imagine a case where the winning attorney requested $139,238 for more than 1,500 hours of paralegal time. Such was the case in Rural Water SYS period NO period 1 versus City of SIOUX Center, Iowa, 38F dot SUPP dot 2D 1057 N dot D dot Iowa 1999, where the court acknowledged and awarded a substantial amount to paralegals in a water dispute between a nonprofit and municipality. Analyze this. Locate a copy of Rural Water Systems Number 1 versus City of Sioux Center, Iowa, 38F SUPP 2D 1057 ND, Iowa, 1999, by typing the case name as noted here in a search engine. Determine what the court observed about the paralegal fees. Did the prevailing party recover all the fees requested? How did the court determine the reasonableness of the fees? (1-7C) Market rates in statutory fee cases. When fees can be shifted in a statutory fee case, how are fees calculated? For attorney's fees, courts use a lodestar under which the number of hours reasonably spent on the case is multiplied by the prevailing hourly rate in the community, called the market rate, for similar work by attorneys. Other factors might also be considered above the lodestar in setting the fee, such as the quality of representation, delay in receiving payment, and risk at the outset of the litigation that the attorney will receive no fee. Before 1989, there was substantial doubt about how paralegal fees would be calculated in statutory fee cases. Would the market rate for paralegal fees be used, similar to how attorney fees are calculated? Assume that an attorney wins a statutory fee case. The attorney requests and receives attorney fees based upon the market hourly rate in the area for attorneys working on this kind of case. The attorney also submits a request for paralegal fees for the time the paralegals spent on the winning case. How does the court determine the amount of paralegal fees to award? Two possibilities exist, only one of which uses the market rate. Prevailing hourly market rate for paralegals. The market rate is the amount on average that law firms in the community charge their own clients for paralegal time. Important example, $110 per hour. Actual cost to the law firm. Actual cost is the amount that a law firm must pay to keep its paralegal. Important example, $50 per hour to cover the paralegal's salary, fringe benefits, office space, and other overhead costs related to maintaining any employee. Of course, the winning side in a statutory fee case will argue that it should receive the market rate for paralegal time, and the losing side will want an actual cost standard. In 1989, the U.S. Supreme Court, in the landmark case of Missouri v. Jenkins, resolved the issue in favor of using market rates. See case in order of the court below. The Jenkins holding does not apply to every statutory fee case, but its influence has been so substantial that the predominant rule today is to use market rates for calculating paralegal fees. The Jenkins case involved a Missouri desegregation suit under Statute 1988 of the Civil Rights Attorneys' Fees Awards Act. This was a federal statute of Congress that allowed fee shifting in civil rights cases. The lower court awarded the winning party $40 an hour for paralegal time, which was the market rate for paralegals in the 1980s in the Kansas City area. On appeal, the losing party argued that it should pay no more than $15 an hour, which at that time was the actual cost to the law firm of having a paralegal in the office. In addition to paralegal fees, the case covered the award of fees for law clerks, who are students still in law school or are law school graduates who have not yet passed the bar. Like paralegals, law clerks are non-attorneys. For convenience, the court refers to paralegals and law clerks collectively as paralegals. As you can see from the opinion, the Supreme Court rejected an actual cost standard for paralegals under the fee-shifting statute the court was applying. Order of the court, a case study. Missouri v. Jenkins, United States Supreme Court, 491, US 274, 109S, CT 2463, 105L, ED 2D 229, 1989. Justice Brennan delivered the opinion of the court. This is the attorney's fee aftermath of major school desegregation litigation in Kansas City, Missouri. One of the issues we need to resolve is, should the fee award compensate the work of paralegals and law clerks by applying the market rate for their work? The litigation began in 1977 as a suit by the Kansas City, Missouri School District, KCMSD, the school board, and the children of 2 school board members against the state of Missouri and other defendants. The plaintiffs alleged that the state, surrounding school districts, and various federal agencies had caused and perpetuated a system of racial segregation in the schools of the Kansas City metropolitan area. They sought various desegregation remedies. After lengthy proceedings, including a trial that lasted 7.5 months during 1983 and 1984, the district court found the state of Missouri and KCMSD liable. The plaintiff class has been represented since 1979 by Kansas City lawyer Arthur Benson, and since 1982 by the NAACP, Legal Defense and Educational Fund, Incorporated, LDF. Benson and the LDF requested attorneys' fees under the Civil Rights Attorneys' Fees Awards Act of 1976, 42 U.S.C. Statute 1988. Benson and his associates had devoted 10,875 attorney hours to the litigation, as well as 8,108 hours of paralegal and law clerk time. The district court awarded Benson a total of approximately $1.7 million and the LDF $2.3 million. On appeal, the defendant now argues that the district court erred in compensating the work of law clerks and paralegals. Hereinafter, collectively, paralegals, at the market rates for their services rather than at their cost to the attorney. While Missouri agrees that compensation for the cost of these personnel should be included in the fee award, it suggests that an hourly rate of $15, which it argued below corresponded to their salaries, benefits, and overhead, would be appropriate rather than the market rates of $35 to $50. To bill paralegal work at market rates makes economic sense. By encouraging the use of lower-cost paralegals rather than attorneys wherever possible, permitting market rate billing of paralegal hours encourages cost-effective delivery of legal services and by reducing the spiraling cost of civil rights litigation. Furthers the policies underlying civil rights statutes. Cameo Convalescent Center Incorporated versus SENN 738 F.2D 836 and 846 CA7 1984. Such separate billing appears to be the practice in most communities today. In the present case, Missouri concedes that the local market typically bills separately for paralegal services. Transcript of Oral Argument 14 and the District Court found that the requested hourly rates of $35 for law clerks, $40 for paralegals, and $59 for recent law graduates were the prevailing rates for such services in the Kansas City area. Under these circumstances, the court's decision to award separate compensation at these rates was fully in accord with Statute 1988 of the Civil Rights Attorneys' Fees Awards Act. A footnote in the opinion refers to an amicus curiae brief filed by the National Association of Legal Assistants, NALA. This is a friend of the court. Appellate brief submitted by a non-party that obtains court permission to file the brief with its views on how the case should be resolved. Keep in mind that Missouri v. Jenkins is a federal case involving one federal statute. The Civil Rights Attorneys' Fees Awards Act. The following categories of cases are not required to adopt the conclusion of Jenkins: federal cases interpreting other federal statutes, state cases interpreting state statutes. For example, a state court applying a state fee-shifting statute could decide to calculate paralegal fees at actual cost rather than at the prevailing market rate. Nevertheless, Missouri v. Jenkins has been persuasive. The vast majority of federal and state courts have adopted its reasoning for allowing paralegal fees at market rates in statutory fee cases. This is why Missouri v. Jenkins is a landmark case. The Jenkins holding was reinforced in 2008 when the Supreme Court held in Richland Security Service Co. v. Chertoff 553 U.S. 571 128 S.C.T. 2007 170 L.E.D. 2D 960 2008 that paralegal fees were recoverable at market rates under a different federal fee-shifting statute, the Equal Access to Justice Act. 1-7D. Challenges to awards of fees in statutory fee cases. Parties who lose statutory fee cases are often understandably upset when they are faced with losing a judgment and paying the attorney fees and paralegal fees of their opponent. A corporation, for example, might lose an antitrust judgment that requires it to pay its opponent $20 million in damages, plus millions more to cover the time spent on the case by the attorneys and paralegals of its opponent. Although the losing side will probably lose the argument that seeks an actual cost calculation of paralegal fees, it may still be able to argue that there are errors in the winning side's request for fees. Let's look at the steps a party takes to request fees and some of the arguments that challenge the request. Challenging fee requests in a statutory fee case. At the conclusion of the trial, the winning side submits to the trial judge a petition that requests attorney and paralegal fees. The petition lists the tasks performed by the attorney and the time taken to perform these tasks. The number of hours is multiplied by the market rate attorneys charge in the area. The result is the total amount requested for attorneys' fees. The petition also lists the tasks performed by a paralegal and the time taken to perform these tasks. The number of hours is divided by the market rate of paralegals in the area. The result is the total amount requested for paralegal fees. The losing side can then present challenges to the fee petition. Here are 3 challenges that will be successful. Some of the tasks performed by the attorney should have been delegated to a paralegal. The attorney should not receive an attorney rate for performing a paralegal task. Some of the tasks performed by the paralegal should have been delegated to a secretary. Paralegal fees in a statutory fee case are limited to substantive legal work, SLW. Paralegal fees cannot be awarded for clerical tasks performed by a paralegal. Some of the tasks performed by the attorney should have been delegated to a secretary. No fees should be awarded for clerical tasks performed by the attorney. There is nothing improper or unethical about an attorney performing a paralegal task or a clerical task. Nor is there anything improper or unethical about a paralegal performing a clerical task. In a busy office that is faced with deadlines or that is shorthanded, everyone must pitch in to do what is needed to respond to immediate client needs. In this environment, you will seldom hear someone say, "That's not my job." However, when the times comes for a request for fees in a statutory fee case, care must be taken to avoid requesting attorney fees for paralegal or clerical tasks, and to avoid requesting paralegal fees for clerical tasks. Suppose, for example, that an attorney performs the following tasks in a statutory fee case. Questions a witness at a deposition, 4 hours. Reads the transcript of the deposition of this witness and highlights each time the witness mentions any health ailment, 2 hours. Negotiates a settlement with opposing counsel, 10 hours. The attorney has spent 16 hours performing these tasks. Assuming the attorney wins the case, a requirement for fee shifting, can they obtain 16 hours of attorney's fees? No. The 2 hours spent looking for health quotes in the transcript is a paralegal task. The request for attorney fees must be limited to the 14 hours spent questioning the witness and negotiating the settlement. For an attorney to seek attorney fees for performing paralegal tasks would be the equivalent of Michelangelo charging Sistine Chapel's rates for painting a farmer's barn. See the footnote in the Missouri v. Jenkins case, in which the court reminded us that the dollar value of a task is not enhanced simply because an attorney performs it. Just as it is improper to seek paralegal fees for clerical tasks, it is also improper to seek attorney's fees for paralegal tasks. A Delaware court in McMacken v. McMacken, 651 A2D 778 780, Family Court of Delaware, 1983, phrased the concern this way: paralegal fees are not a part of the overall overhead of a law firm. Paralegal services are billed separately by attorneys, and these legal assistants have the potential for greatly decreasing litigation expenses and, for that matter, greatly increasing the efficiency of many attorneys. By permitting paralegal fees, the danger of charging these fees off as the attorney's work is hopefully extinguished. By the same token, the danger of charging off a secretary's services as those of a paralegal is very real and present. Analyze this. Research whether your state permits paralegal fees to be charged as part of an attorney's fee award. If so, what is the market rate for paralegals in your area? Has a court identified what paralegal services can be considered appropriate billing services? Has a court identified what paralegal services can be considered appropriate billable services? What is that criteria? (1-7E) Record keep. Timekeepers, attorneys and paralegals, must keep careful records of the tasks they perform and the amount of time spent on each task. Accurate timekeeping records of this kind will be used to help a court distinguish among attorney, paralegal, and clerical tasks. Again, it is not enough for an attorney to say that task X is an attorney task simply because an attorney performed it, or that task Y is a paralegal task simply because a paralegal performed it. The court will want to look at the nature of the task itself in order to determine who should have performed it. fees will be awarded on the basis of this determination. It is standard practice in most private law firms for timekeepers to keep detailed timesheets covering the entire workday. A paralegal's supervising attorney may need to enter these timesheets into evidence to justify the award of paralegal fees in statutory fee cases. Here is an example of what some courts require attorneys to demonstrate in their petition for paralegal fees. The services performed by the paralegal must be legal in nature. 2. The performance of these services must be supervised by an attorney. 3. The qualifications of the paralegal performing the services must be specified in the request for fees in sufficient detail to demonstrate that the person is qualified by virtue of education, training, or work experience to perform substantive legal work, SLW. 4. The nature of the services performed must be specified in the request for fees in order to allow the reviewing court to determine that the services performed were legal rather than clerical. 5. As with attorney time, the amount of time expended by the paralegal must be set forth and must be reasonable. And 6. The amount charged must reflect reasonable community standards, the market rate for charges by paralegals. Quick tip. After you complete a task, always take the time to enter your billable time into the record-keeping program of the firm. There is no time like the present. This recording should include not only drafting documents and attending meetings, but other tasks such as calling and emailing clients, for example. 1-7F. Summary of rules on fees. To summarize the rules on paralegal fees, let's look at A. All cases in which attorneys can charge their own clients paralegal fees, and B. Special statutory fee cases in which the losing side can be ordered to pay the paralegal fees of the winning side. In all cases, 1. Attorneys can charge their own clients a separate fee for the work of their paralegals, regardless of who wins the case. This is in addition to charging for the attorney's time. If the fee agreement says that the paralegal fee shall be for paralegal tasks, the firm should not charge for clerical tasks performed by the paralegal. 2. Timekeepers must keep detailed records, for example, timesheets, on the tasks they perform and the time spent performing them. contemporaneous record keeping is preferred over time records that are assembled long after the task is performed. 3. The amount of time a timekeeper takes to perform a task must be reasonable in light of the nature and complexity of the task. 4. The amount of the fee itself must be reasonable. In statutory fee cases, 1. The loser can be required to pay the attorney and paralegal fees of the winner. 2. The attorney will be required to demonstrate the paralegal's qualifications. Important example, education and experience, for the fees requested. 3. Attorney fees cannot be awarded when an attorney performs paralegal tasks. 4. Paralegal fees cannot be awarded when a paralegal performs clerical tasks. 5. The amount of the fee is based on the prevailing market rate that attorneys in the legal community charge their clients for paralegal tasks. This market rate rule applies if a court adopts the rationale of Missouri v. Jenkins, as most courts have. 1-8 Career ladders in large law offices. There is no career ladder for paralegals working in a small law office that consists of one or several attorneys, a secretary, and a paralegal. In an office with more than 3 paralegals, career ladders are more likely to exist. When they exist, firms use a wide variety of titles. Exhibit 1-3 presents 2 examples used in law firms and 2 used in the law department of a large corporation. Exhibit 1-3 Examples of paralegal career ladders. Sample career ladders in 2 large law firms. Paralegal 1, entry level. Paralegal 2, intermediate. Paralegal 3, supervisory. Sample career ladders in the law departments. Entry level legal assistant, 0 to 1 year experience. Legal assistant, 1 to 3 years of experience. Senior legal assistant, level 1, 4 to 7 years of experience. Senior legal assistant, level 2, 8 to 12 years of experience. Corporate legal assistant, level 1, 13 plus years of experience. Corporate legal assistant, level 2, 20 plus years of experience. Specialist experience requirement depends on at the top of most career ladders where they exist is the paralegal coordinator or manager with duties such as recruiting and screening candidates for paralegal positions, orienting new paralegals, to office procedures, training paralegals to operate software used in the office, training paralegals to perform certain substantive tasks such as digesting, i.e., summarizing, pretrial testimony, coordinating assignments of paralegals among the different attorneys in the office to help ensure that paralegals are given assignments they are able to perform and that they complete them on time. Chapter 5 will provide more details on the role of the paralegal manager. As indicated earlier, paralegal managers have performed their own association, the International Practice Management Association. 1-9 Paralegal salaries. How much do paralegals make? Although some data are available to answer this question, there is no definitive answer because of the great variety of employment settings. Factors such as geographical location, experience, and specialty are just a few considerations. For example, a starting salary for a paralegal with 0 to 1 years of experience in a large city such as Miami could range between $55,000 and $65,000. While a paralegal at the same level in a smaller city could be $41,000 to $47,000 yearly. As you gain experience, the salary increases. Another component of salary is the geographical area. With differing cost of living factors, salaries will reflect where a paralegal is living, urban, suburban, or rural area. An experienced senior paralegal in New York City or San Francisco may have a salary range in the low to mid 100,000s compared to Atlanta or Dallas in the low to mid $80,000 range. According to the Bureau of Labor Statistics of the U.S. Department of Labor, the median salary of the 345,240 paralegals in the country was $62,840 in 2022. The median wage is the wage at which half the workers in an occupation earned more than the median amount and half earned less. The top 10% of paralegals earned more than $94,060. The bottom 10% of paralegals earned less than $37,690. NALA regularly performs surveys of the paralegal salary ranges. The survey also examines billable rates, responsibilities, and growth of the profession. It provides a good snapshot of the current and future direction of the paralegal profession. Analyze this. In any search engine, locate a copy of the most recent NALA survey and determine 1. The expected growth of the profession. 2. The average annual salary of a paralegal, and 3, the type of benefits received by paralegals from their employers. Experienced paralegals do very well. If they have good resumes and have developed specialties that are in demand, they usually improve their financial picture significantly. A number of other generalizations can be made about salaries across the country. Skilled paralegals and those with considerable responsibility earn high salaries. Paralegals who meet or exceed billable hour expectations tend to be rewarded with higher salary increases and bonuses. Paralegals who work in large private law firms and tend to make more than those who work in smaller private law firms. Paralegals who work in large metropolitan areas over 1 million in population tend to make more than those who work in rural areas. Paralegals who work in legal aid or legal service offices that are funded by government grants and charitable contributions to serve those with low incomes tend to make less than most other paralegals. Paralegals who work for attorneys who understand the value of paralegals tend to make more than those working for attorneys who have a poor or weak understanding of what paralegals can do. Paralegals who work in an office where there is a career ladder for paralegals, plus periodic evaluations and salary reviews, tend to make more than those who work in offices without these options. Paralegals who are career-oriented tend to make more than those less interested in a long-term commitment to paralegal work. In addition to the payment of bonuses, other fringe benefits are also relevant to the overall compensation picture. Vacation time, health insurance, and parking facilities. For a geographical profile as to the average salaries of paralegals and legal assistants, see Exhibit 1-4 from the U.S. Bureau of Labor Statistics. Bureau of Labor Statistics, U.S. Department of Labor, Occupational Outlook Handbook, Paralegals and Legal Assistants at https://www.bls.gov/OOH/legal/paralegals and legal assistants.htm. Visited May 22nd, 2023. Exhibit 1-4. Mean salary of paralegals and legal assistants by state. Annual mean wage of paralegals and legal assistants by state, May 2022. Annual mean wage. quick tip. A paralegal that has a specialty certification increases their value and, in turn, their demand and salary. Consider taking the step toward specialty certification, either through passing an exam or through specialized education programs. 1-10 Factors influencing the growth of paralegalism. In the late 1960s, most attorneys would have drawn a blank if you mentioned the words paralegal or legal assistant. According to Webster's Ninth New Collegiate Dictionary, the earliest recorded use of the word paralegal in English occurred in 1971. Today, the situation has changed radically. Most law offices either employ paralegals or are seriously considering doing so. A major exception to this trend is the 1 or 2 attorney office in which the only staff member is a secretary who often performs paralegal tasks. Some surveys show that there is 1 paralegal for every 4 attorneys in law firms and 1 paralegal for every 2 attorneys in the law departments of corporations. It has been estimated that the number of paralegals may eventually exceed the number of attorneys in the practice of law. The U.S. Bureau of Labor Statistics says that there are about 45,800 openings for paralegal jobs projected each year over the next decade. That is between 2021 and 2031. Employment will grow by 14%, faster than the average for all occupations. See Exhibit 1-5 from the Bureau of Labor Statistics, U.S. Department of Labor, Occupational Outlook Handbook, Paralegals and Legal Assistants at www.bls.gov/OOH/legal/paralegals and legal assistants.htm. Visited May 22nd, 2023. Exhibit 1-5 Employment of Paralegals and Legal Assistants by State. Employment of Paralegals and Legal Assistants by State, May 2022. What has caused this dramatic change? The following factors have been instrumental in bringing paralegalism to its present state of prominence. 1. The pressure of economics. 2. The call for efficiency and delegation. 3. The promotion by bar associations. 4. The organization of paralegals. 1. The pressure of economics. Perhaps the greatest incentive to employ paralegals has been arithmetic. Law firms simply add up what they earn without paralegals, add up what they could earn with paralegals, compare the two figures, and conclude that the employment of paralegals is profitable. There can be little doubt that the principal motivation prompting law firms to hire paralegals is the economic benefit enjoyed by the firm. The key to increased profits is leveraging. Leverage, often expressed as a ratio, is the ability to make a profit from the income-generating work of others. The higher the ratio of paralegals to partners in the firm, the more profit to the partners or owners of the firm, assuming that everyone is generating income from billable time. The same is true of associates in the firm. The higher the ratio of associates to partners, the greater the profit to the partners and owners. In the best of all worlds, some of this increased profit will result in lower fees to the client. For example, Chief Justice Warren Burger felt that some attorneys charge excessive fees for tasks such as closing real estate transactions for the purchase of a home. A greater part of that work can be handled by trained paralegals, and, in fact, many responsible law firms are doing just that to reduce costs for their clients. If the state requires an attorney to do all the work at closing, the law would have to be changed to allow paralegals to do what Chief Justice Burger suggests. We discuss such changes in Chapter 4. The higher the ratio of associates to partners, the greater the profit to the partners and owners. With a paralegal added to the legal team, the firm's profit is increased. The average billing rate attorneys charged clients for paralegal time ranges based on factors such as geographical area, experience, and specialization, to name a few. You can expect to be billed from $75 upwards to $150 per hour. The larger metropolitan areas will have the highest billable rates compared to smaller cities and towns. Paralegals with these billing rates are expected to produce a set number of billable hours per week. Most work 40-hour work weeks and are asked to bill at least 30 hours. An expectation of this kind is called a billable hour quota or billable hour goal. Not all of a paralegal's performance is billable, and they often perform non-billable tasks. These tasks cannot be billed to clients. Examples include recruiting new employees, helping to maintain the law library, training other paralegals, organizing the office's closed case files, and doing some of the work on certain kinds of cases that an attorney would normally do for free. Probating the estate of the attorney's brother-in-law, for example. The more non-billable tasks, such as these, that a paralegal performs, the less time they will have available to devote to billable tasks. This, however, does not mean that the paralegal is not a profitable member of the team. A non-billable task that a paralegal performs is often a task that the attorney, at least in part, does not perform. A non-billable task that a paralegal performs is often a task that the attorney, at least in part, does not have to perform. This, of course, enables the attorney to direct more of their efforts to fee generating. Important example, billable matters. Directly related to a paralegal's profitability is one's realization rate. A law firm does not always collect 100% of every bill it sends to its clients. Some clients simply refuse to pay, or they bargain down the bills initially sent to them. The realization rate is the percentage of the total amounts billed to clients that a law office actually collects. If, for example, the office fails to collect 10% of all the bills sent out during a given period, its realization rate is 90% for that period. Attorneys and paralegals have realization rates based on the percentage of the amounts billed from their hours that were actually collected. Of course, a paralegal has no control over whether the office is able to collect every billable hour submitted. Yet, many paralegals inquire about their current realization rate for their own information and possible use when discussing their value to the office, perhaps at an annual review and bonus time. 2. The call for efficiency and delegation. Attorneys are overtrained for many of the tasks that they once had to perform in a traditional law firm. It eventually became clear that this was not the way to run an efficient office. The creation of the paralegal role was a major step toward reform. The results have been quite satisfactory, as noted by the growth of the profession discussed earlier in this chapter. The following historical perspective presents an overview of how attorneys and the profession came to realize the importance and value of paralegals. Historical background. Attorneys have often placed a high premium on the personal relationship between attorney and client, and in the early history of the practice of law, delegation of tasks rarely occurred. Imagine handwriting everything and thinking that technological advancement, such as a typewriter, was unwelcomed. As late as 1875, for example, Clarence Seward and his partners would have none of the newfangled typewriters because clients would resent the lack of personal attention implied in typed letters. The coming of the Industrial Revolution, however, brought about change in the practice of law. Some law offices began to specialize. As attorneys assumed new responsibilities, the concern for organization and efficiency grew. Many law offices in the 1850s, however, took a different direction. Machines created new jobs. The typewriter introduced the typist. Librarians, investigators, bookkeepers, office managers, accountants, tax and fiduciary specialists, and research assistants soon found their way into some large law offices. Although non-attorneys were hired primarily to undertake clerical or administrative responsibilities, they were soon delegated more challenging roles. This was not always done in a planned manner. An employee might suddenly be performing dramatically new duties as emergencies arose on current cases, and as new clients arrived in an already busy office. In such an environment, an attorney may not know what the employee is capable of doing until the employee does it. Despite its haphazard nature, the needs of the moment and OJT, on-the-job training, worked wonders for staff development. By the 1960s, attorneys started to ask whether a new kind of employee should be created. Instead of expanding the duties of a secretary, why not give the expanded duties to a new category of employee, the paralegal? A number of studies were conducted to determine how receptive attorneys would be to this idea on a broad scale. The results were very encouraging. The conclusion soon became inevitable that attorneys can delegate many tasks to paralegals. Today, this theme has become a dominant principle of law office management. Most attorneys no longer ask, "Can I delegate?" Rather, they ask, "Why can't this be delegated?" Or, "How can the delegation be effectively managed?" It is a given that substantial delegation is a necessity. 3. The promotion by bar associations. The bar associations assumed a large role in the development of paralegals. This has given great visibility to the field. In 1968, the House of Delegates of the American Bar Association established a special committee on lay assistance for lawyers, subsequently renamed the Standing Committee on Paralegals, and resolved: 1. That the legal profession recognize that there are many tasks in serving clients' needs which can be performed by a trained non-lawyer assistant working under the direction and supervision of a lawyer. And 2, that the profession encourage the training and employment of such assistants. Most of the state bar associations now have committees that cover the area of paralegal utilization. Many of these committees have established guidelines for the use of paralegals in a law office. At present, no paralegals are full members of any bar association. In recent years, however, a number of state and local bar associations have invited paralegals to join their organizations in various capacities. The association might allow the paralegals in as associate or affiliate members of the entire association, including its committees and sections. Associate or affiliate members of committees or sections only, or full members of special paralegal divisions. Bar associations have different requirements for paralegal membership. For example, an attorney attestation may be required, in which an attorney member of the bar attests that the applicant performs substantive legal work, SLW, under attorney supervision. An example of an active paralegal unit of a bar association is the Paralegal Division of the State Bar of Texas, www.txpd.org. It has more than 2,300 members. In some of the bar associations, paralegals are allowed to vote on issues within the section, committee, or division of which they are members, but they cannot vote on general bar association issues. In 1982, the ABA Standing Committee on Paralegals proposed that the ABA create an associate category of membership for paralegals. NALA warmly endorsed the proposal, but NFPA opposed it on the grounds that paralegals organizations should be autonomous and should not become part of a state or national association that regulates them. NFPA and others argued that the organized bar had a conflict of interest in regulating paralegals in light of the profit motive attorneys have in using paralegals. Today, however, this concern is rarely, if ever, raised. Paralegals take advantage of bar membership for a number of reasons. It looks good on a resume. It fosters a positive relationship between paralegals and attorneys. Employers often pay all or part of the paralegal's membership fee. Bar association meetings can be an excellent place for networking. Members receive paper or online newsletters and announcements, thus keeping them better informed about developments in the legal community. Online exercise. Find out whether your state or local bar associations permit paralegal membership. If so, determine the qualifications to become a member. Quick tip: ask the first opportunity. At the first opportunity, join the national and local paralegal organizations to begin networking and establishing contacts within the legal profession. Volunteer for committees in the organizations to increase your professional opportunities and visibility. 4. The organization of paralegals. Paralegals have been organizing. There are approximately 200 paralegal organizations throughout the country. See Appendix A. This has greatly helped raise everyone's consciousness about the potential of paralegalism. We will be examining the work, impact, and value of these associations in the next several chapters. (1-11) Oh, you're studying law. Can the landlord put my furniture out on the curb? What happens if I co-sign the note and it's not paid? Once your friends and relatives find out that you are studying law, you will probably start receiving legal questions such as these. Later, in Chapter 4 and 6, we will examine legal advice in some detail. You need to be very careful to avoid giving such advice. You do not want to begin your legal career with a charge of engaging in unauthorized practice of law. Politely refuse to answer all questions that seek to find out how the law applies to particular fact situations. Even if you know the answer, the proper response is, "That's something an attorney would have to look into," or simply say, I don't know. That tells us how we should respond to Aunt Mary in our fact scenario at the beginning of the chapter. I don't know. Practice saying aloud, I don't know. I don't know. The Aunt Marys of the world will always try and push the boundaries of what you are permitted to say and do. Know what your ethical obligations are as a paralegal and learn how to deal with family and friends by declining to render legal advice. As we will discuss in later chapters, no paralegal wants to be accused of unauthorized practice of law, and no one wants to be in the middle of family or friends with legal issues. (1-12) Your online reputation. It matters. In today's computer-driven environment, the likelihood is strong that prospective employers will be seeking information about you online. What will they find? Your online reputation is your brand. How you stand out, what makes you distinctive. As a professional, you will need an online presence, and it must be informative, intelligent, engaging, and conservative. In later chapters, we will cover ways to achieve such a presence through LinkedIn, Facebook, X, and other social media sites. For now, the watchword is caution. Again, we will have more to say about building a positive online presence. In the meantime, find out what that presence is today and start learning how to remove and avoid anything negative. Quick tip: learn what the internet currently has to say about you by entering your name as a search term in a search engine. If you are not satisfied with what you see, 1. Perform this search: how to clean up your image on. In the blank, insert the name of any site you have joined. 2. If something exists about you online that would not impress a prospective employer, follow the cleanup instructions of the site involved to try to remove it. (1-13) Conclusion. As we will learn in subsequent chapters, there have been some dramatic developments in paralegalism in recent years. Beginning in 2000, when California inaugurated a major program of paralegal regulation. This has prompted many other states to consider their own versions of regulation. Furthermore, the practice of law, legal education, and legal profession are going through a period of re-examination. Change is clearly in the air. In a keynote address, Robert Stein, executive director of the American Bar Association, said that the four most important areas affecting the practice of law in the future were diversity, globalization, electronic contracts, and the growth of paralegalism. The paralegal profession, he said, is undergoing a remarkable transformation as the value of a well-trained paralegal is recognized by more and more law firms, corporations, and governments as a means of providing cost-effective services in an area of rising expenses and complex litigation. Echoing these themes, a recent study of the practice of law came to the following conclusions. The combined forces of globalization, technology, and market liberalization are creating new services, new delivery mechanisms, and new forms of competition. Those changes are altering client needs and expanding client expectations. Clients want services to be quicker, cheaper, and smarter. They want more transparency and involvement. And they want to be and stay connected. These are some of the themes we will be exploring as you now begin the journey of becoming a well-trained paralegal. Real-world perspectives. On the job observations. Employment opportunities in the paralegal world are plentiful and varied. The areas of practice are practically limitless with the development of new technologies and other specialty areas of the law, such as cannabis regulation. One area where paralegals also serve an important purpose is in the military court system. A paralegal working in the judge advocate's office had this to say about the varied nature of the practice. I have been working for the office of the staff judge advocate, SJA, at Fort Ord, California. The SJA, Office of the Staff Judge Advocate, is the Army's lawyer. We serve a military community of just over 90,000 people. Staff within the SJA, Staff Judge Advocate, consists of a combination of military and civilian attorneys, paralegals, legal clerks, and court reporters. I am responsible for claims filed against the federal government under the Federal Tort Claims Act. I am responsible for discovery and investigative efforts, determining legal issues, writing memoranda of law, and recommending settlement or denial. Job satisfaction for paralegal professionals is high in the U.S. government. I know that, should I desire to re-enter the civilian work sector, My experience and knowledge of the government legal systems will uniquely qualify me to work for any firm that deals with the government. Richards, marching to a different drummer. Paralegal work in the military. To California Paralegal Magazine 8. The rewards are great as you enter the legal profession. As a veteran paralegal noted with initiative, a paralegal will have more opportunities to become an invaluable member of the legal team. At a paralegal conference, Virginia Henderson made a seminar presentation on her duties as a paralegal. Her candor and energetic enthusiasm concerning her profession were encouraging and motivating. She was very explicit about her duties as a commercial real estate paralegal, explaining that attorney supervision is lessened once the paralegal assumes more responsibility and exhibits initiative as far as his or her duties are concerned. It was refreshing to listen to a veteran of the paralegal profession speak so optimistically about the profession's limitless potential. Here's to having more paralegals as seminar speakers. Troiano Real Estate. Newsletter 12, Western New York Paralegal Association. Chapter Review 1-14A. Chapter Summary. Launching Your Career. The law has a wide-ranging impact on your society. A large percentage of individuals and companies need legal assistance. You can use your paralegal education to engage in so many fields, including politics, securities, and estates law. Do you know what time it is? Precision matters. Precision and attention to detail are critical attributes of anyone working in the law. Another characteristic of the law is its focus on definitions and intentions of the parties. The study of the law is and can be rewarding and fulfilling. The scope of your legal education. Your legal education will require you to understand the court system and understand the ethical and professional responsibility of legal professionals. Writing and critical thinking are essential components of your education. Proficiency in technology and adaptability is important as well. Major players. Organizations for paralegals. Important organizations in paralegalism include National Federation of Paralegal Associations, NFPA, National Association of Legal Assistants, NALA, National Association of Legal Support Professionals, NALS, the American Bar Association, ABA, your state bar association, your local paralegal association, and the American Association for Paralegal Education, AAFPE. The National Paralegal Associations offer certification and, along with the bar associations, promote continuing legal education, CLE. Job titles. What's in a name? Although some laws and organizations assert that the titles paralegal and legal assistant are synonymous, the preferred title has become paralegal, as more and more legal secretaries are called legal assistants. Some states have laws that restrict the use of specific titles, but most states have no such restrictions. Paralegals are either employees of attorneys, traditional paralegals, or independent contractors who sell their services to attorneys or who have authorization to sell limited services directly to the public without attorney supervision. B. Some law firms divide their paralegals into two broad categories: litigation paralegal and transactional paralegal. C. Paralegals' specialties include such areas of the law and practice as bankruptcy, corporate, family law, real estate paralegals, and e-discovery, to highlight a few. D. In some small offices, paralegals are likely to perform a variety of paralegal, bookkeeper, librarian, investigator, secretary, and receptionist tasks. E. Independent contractors who work without attorney supervision are document service providers, DSPs. They need to be mindful of what constitutes the unauthorized practice of law in their jurisdiction. For example, if a paralegal works in the bankruptcy area, they must call themselves bankruptcy petition preparers. In California, they must be called legal document assistants or unlawful detainer assistants. A few other states have similar restrictions and limit the use of the titles paralegal and legal assistant to those who work under attorney supervision. Definitions of a paralegal. A paralegal is a person who performs substantive legal work, tasks on behalf of others when those tasks are supervised by an attorney who would be required to perform the tasks if the office did not have a paralegal. B. Definitions of a paralegal have been written by legislatures, courts, the American Bar Association, local bar associations, and paralegal associations. C. The three most common characteristics of the definitions are that the paralegal has required legal skills through education, training, or on-the-job experience, works under attorney supervision, and performs substantive, important example, non-clerical, legal work that the attorney would have to perform if the office did not have a paralegal. 1. The absence test states that a task is a paralegal task if it must be performed by an attorney if the office does not have a paralegal. This test requires that you analyze who could perform the task, not who actually performs the task. 2. Substantive legal work is non-clerical work. It does not include clerical or administrative work. Paralegal fees. A. In most states, attorneys can charge their clients paralegal fees in addition to fees for attorney time. 1. Attorney fees and paralegal fees are distinguished from court fee costs. Special expenses and operating expenses. Most clients will pay all fees except for operating expenses. 2. The document that solidifies the attorney-client relationship is the engagement letter or retainer agreement, which sets forth the fee arrangement. Fees can either be hourly or contingent. B. There are 3 situations where fee shifting occurs: prior agreement, bad faith, and special statute. In statutory fee cases, the losing side in litigation can be forced to pay the attorney's fees of the winning side. 2. These fees can include separate fees for paralegal tasks. 3. Under the landmark civil rights case of Missouri v. Jenkins, a statutory fee case that has been followed by many state courts and by many federal courts in non-civil rights cases, paralegal fees are determined by market rate. 4. Paralegal fees in statutory fee cases are limited to substantive legal work performed by paralegals. 5. Paralegal fees cannot be awarded in such cases for clerical tasks. A. Fee challenges in statutory fee cases can include claims that some of the tasks performed by the attorney for which fees that are requested should have been delegated to a paralegal, and some of the tasks performed by the paralegal for which fees are requested were clerical. 1. Paralegals must keep detailed and preferably contemporaneous records that specify the tasks they performed. 2. In summary, attorneys can charge for reasonable attorneys' fees, including paralegal fees, when performing substantive legal work. Statutory fees are paid by the losing party and also must be documented and reasonable at market rates for both the attorney and paralegal. Career ladders in large law firms. Career ladders for paralegals exist mainly in law offices with more than 3 paralegals. Paralegal managers in large offices help recruit and train paralegals and coordinate their assignments. Paralegal salaries. Paralegal salaries are influenced by a number of factors: experience, skills, level of responsibility, kind of employer, geographic area, meeting billable hour expectations, the employer's understanding of the paralegal's role, and the extent to which the paralegal is committed to the field as a career. Specialty training increases a paralegal's demand and, in turn, a salary. Factors influencing the growth of paralegalism. A. Bar associations and paralegal associations have promoted the value of paralegals extensively. The economic impact they have had on the practice of law is the major reason the paralegal field has flourished and grown so rapidly. B. In a properly leveraged firm, paralegals can be a profit center without any sacrifice in the quality of the service delivered by the firm. Also, a paralegal can help attorneys redirect some of their energies from non-billable to billable tasks. This involves delegation and efficiency. Oh, you're studying law. Avoid the temptation to render any legal advice simply because you are studying law. Politely refuse to answer any legal questions rendering advice. Your online reputation. It matters. Employers will seek information about you online. Be sure your online presence is professional and learn about ways to clean up your profile image. Chapter Review 1-14B. Key terms: continuing legal education, certification, networking, traditional paralegals, independent contractors, transactional paralegal, sole practitioner, referee, independent paralegal, document service providers, DSPs, unauthorized practice of law, UPL, paralegal, fees, paralegal fees, contingent fee, court costs, engagement letter, American rule, English rule, fee shifting, bad faith, frivolous, aggrieved, virtual paralegal, statutory fee cases, lodestar, law clerks, amicus curiae brief, timekeeping, leveraging, billable, closing, billable hour quota, realization rate, attorney attestation, legal advice. Chapter Review 1-14C. Review questions. 1. Where do most paralegals work and why? 2. What are the major organizations in the development of paralegalism? What is certification And which national paralegal associations have certification exams? 3. How have state bar associations affected the development of paralegalism? 4. What is the distinction between traditional paralegals and paralegals who are independent contractors? 5. What are some of the major titles that employers use for traditional paralegals? A. What are some of the major titles that employers use for entry-level paralegals? B. What are some of the major titles that employers use for supervisory paralegals? C. What are some of the duties of a paralegal coordinator or manager? 6. Distinguish between a generic and a specific title of a paralegal. A. What is an e-discovery paralegal, compliance paralegal, conflicts specialist, nurse paralegal, and legal nurse consultant? B. What is a transactional paralegal? 7. What is the unauthorized practice of law? 8. What is the definition of a paralegal? A. What entities or organizations have adopted definitions of a paralegal, and which definitions are the most significant? B. What 3 characteristics are common to most definitions of a paralegal? 9. What are the 2 ways that paralegals acquire legal skills? 10. Distinguish fees, attorney and paralegal, court costs, special expenses, and operating expenses. Distinguish between an hourly fee and a contingent fee. 11. What is the document called that specifies the payments a client will make to a law office? What are the 2 types of fee arrangements between a client and lawyer? 12. What is a statutory fee case? A. What tasks performed by a paralegal can and cannot be the basis of fees in a statutory fee case? B. When a party loses a statutory fee case, what kinds of challenges does the party sometimes make against the request for fees by the winning side? 13. What was decided in Missouri v. Jenkins? A. Why is this a landmark case? B. Based on Missouri v. Jenkins, provide examples of a paralegal's billable and non-billable tasks. 14. What factors determine paralegal salaries? 15. Name 4 major factors that have been instrumental in the emergence of paralegalism to its present state of prominence. Chapter Review 1-14D. Assignments. Critical Analysis. 1.1. Assume that you had 2 employment offers. In one, the title of the position is paralegal. In the other, it is legal assistant. A. What factors would you consider about the 2 positions in making a decision about which position to accept? A. Assume the duties of the two positions are substantially the same, but the salary of the legal assistant position is 10% higher than the paralegal position. How would you go about making a decision? 1.2. A. Justice William Brennan in Missouri v. Jenkins said that using a market rate for paralegals will help reduce the spiraling cost of civil rights litigation. How can forcing a losing party to pay more for paralegals reduce the cost of litigation? B. Examine the full text of Missouri v. Jenkins to determine why Chief Justice William Rehnquist filed a dissenting opinion on paralegal fees. Why did he say that allowing paralegal fees would amount to double recovery? You can access the case in a traditional or online library to examine the opinion. Use FindLaw, www.findlaw.com. In citation search for FindLaw, type 491 in the first box and 274 in the second box so that it reads 491 US 274. Also, use a search engine and type in the name of the case. Numerous online sites will be revealed that have the opinion for review. Projects. 1.3. Follow 3 employers in the following areas to determine whether they have paralegal job opportunities. 1. U.S. government, such as U.S. Department of Justice or other department. 2. State government, such as Attorney General's office, district and state attorneys, or other state departments. 3. Law firm or corporation. Once you have chosen your employers, A. Determine the job title, salary, and benefits. B. Identify the level of experience required for the job. C. Periodically check these employers for job future opportunities. Chapter Review 1-14E. Core Skills Assignments. Among the many skills a paralegal must have, 5 core skills stand out: writing, both basic English and legal drafting; research; ethics, computer use, and collaboration, working with others. The core skill assignments introduce and reinforce these skills. Even if you are not asked to do all of the core assignments as part of the course, you should do them on your own. Also, do not wait for the topics in the assignments to be covered in this course or in other courses. Successful paralegals are self-starters. A major characteristic of a self-starter is a thirst for independent study, learning on your own. Core skill writing. 1.4. Perform a search on any search engine, such as Google, Bing, or Yahoo, with the search words common writing mistakes. A. Identify the top 10 most common writing mistakes. List the websites that you used to answer this question. B. Now perform the same search but add the word legal to your search. Identify the top 5 most common legal writing mistakes. List the websites that you used to answer this question. C. Determine whether there are common writing mistakes in general writing and legal writing. Keep a record of the common writing errors for use in Chapter 10, Legal Writing. Core Skill Research 1.5. A. What is the website of the main state judicial system in your state? Search in Google, Bing, or Yahoo. AA Courts, substituting your state for AA. B. What is the website of your state legislature? Search any search engine with AA legislature, substituting your state for AA. C. What are the websites of Congress, the U.S. Senate, and the U.S. House of Representatives? Perform separate searches. Congress, United States Senate, United States House of Representatives. Core Skill Ethics 1.6. A. What is the name of the code of ethics that governs attorneys in your state? What is the website where you can find the text of this code? Search using Attorney Ethics, AA, substituting your state for AA. B. Determine whether your state has a code of ethics that applies directly to paralegals. Check state and local paralegal associations. If none exists, locate a copy of the Rules of Ethics on the American Bar Association website. Keep a copy of the sites and information for use later in the textbook. Core Skill Computers 1.7. Start a computer notebook, paper or digital. Call it computer terminology in the law, CTL. Throughout the course, make entries in your CTL notebook. There will be 2 main categories of entries in the CTL. A. General computer terms, and B. Specific computer software. General computer terms consist of any term connected with computers other than the names of specific products or companies. For an example, database management, cloud computing. Specific computer software consists of the names of software products. For an example, Word, concordance, summation, time slips. You do not have to wait to have a course or lecture on these concepts before beginning to collect the vocabulary of computers and the law. To start making entries in the CTL, perform the following searches online. Commonly used software for attorneys. Popular law firm computer products. Survey computer trends attorney. From these searches, select any two general computer terms and any two software products that are used by law firms. In the CTL, write or type a few sentences describing your four terms. The physical act of writing or typing them will enhance the learning process. Don't worry about alphabetizing the entries in the CTL. Also, don't expect to understand the terms fully at this early stage. The goal now is simply to collect definitions and to write or type them. The world of computers is complex. You will continue learning about computers throughout your career. The starting point is terminology. Core skill, collaboration. 1.8. Pick a task that you know how to perform on a computer. For example, write out the instructions on how to place an out-of-office notification on your email, or how to add in a signature block with office information to all outgoing emails. Write out detailed instructions on how to perform this task. Find someone, for example, a fellow student, who does not know how to perform this task, but who has the facilities needed to perform the task. A computer, particular software, internet access, etc. Give the written instructions to this person and ask them to perform the task solely by following your written instructions. Have the person report back to you on whether they could do the task. If possible, let this person show you that they can do the task. Do not give oral instructions. The person should try to do the task solely by reading your instructions. A. What task did you select? B. Describe whether the person was able to perform the task, either by what this person reported back to you or by what you observed. C. What lessons did you learn about working with another person whom you are trying to train? The job search. The search for employment cannot wait until the end of a course or of a curriculum. It should begin now. The job search assignments are designed to introduce you to different aspects of the job search and to build options for you to explore about employment. 1.9. In any search engine, perform the following searches, substituting your state for AA. Law firms, AA. Large law firms, AA. A. Pick any 5 law firms in your state that mention paralegals on their website. On the homepage of each site, click words such as careers, employment, join us, opportunities, people, or any other words that invite the viewer to learn about personal On the homepage of each site, click words such as careers, employment, join us, opportunities, people, or any other words that invite the viewer to learn about personnel at the firm. On the sites that you select, what job titles or job descriptions do you find for individuals who are neither attorneys nor secretaries? Summarize what you find. Include the website of each site you use. B. Do any of the sites you selected mention job openings for paralegals? Summarize what you find. C. Perform a search of your states. 1. Attorney General's Office. 2. State Legislature. 3. Education, Human Services, Health, or Finance Departments, or the equivalent. Determine whether there are any jobs listed for paralegals or related type jobs. Write those jobs and sites down for future reference. Chapter Review 1-14F Portfolio Binder Assignment. Throughout this textbook, you will be asked to create a portfolio binder that you can use for interviews with prospective employers. Use on the job or use as an archive for your work in this class as well as others. It should be an example of your work as well as a depository for anything related to your paralegal career. Depending on your preference or the professor's instructions, create either a traditional hard copy or electronic version of a portfolio binder for you to build on as this class and others progress. It should be your showcase and your reference guide. Assignment 1. List the paralegal organizations that will be helpful in providing job opportunities. Assignment 1. List the paralegal organizations that will be helpful in providing job and continuing legal education opportunities, including state and local organizations. Include the websites for future reference. Place in your binder. Assignment 2. Determine the general salary range for an entry-level paralegal position in your jurisdiction. Include salaries for a mid-level and experienced level position. Assignment 3. Write down the position you aspire to and identify your dream position. That will now be the goal of your portfolio binder. Continuing Legal Education, CLE. Training in the law, usually short-term, that a person receives after completing their formal legal training or after becoming employed. Certification. The process by which a non-governmental organization grants recognition to a person who has met the qualifications set by that organization. Networking. Establishing contacts and sharing information with people, A, who might become personal or professional resources for you, and B, for whom you might become a personal or professional resource. Traditional paralegals. A paralegal who is an employee of an attorney. Independent contractors. A self-employed person who operates their own business and contracts to perform tasks for others. In general, the latter do not control many of the administrative details of how the work is performed. Transactional paralegal. One who provides paralegal services for an attorney who represents clients in transactions such as entering contracts, incorporating a business, closing a real estate sale, or planning an estate. A paralegal who does not work in litigation. Sole practitioner. An attorney who practices alone. There are no partners or associates in the office. Referee. A person appointed by the court to take testimony, hear parties, and report to the court their findings, which may be accepted, rejected, or modified by the court. Judicial officer who is an arm of the court for a specific purpose. Independent paralegal. One, an independent contractor who sells their paralegal services to and works under the supervision of one or more attorneys. 2, an independent contractor who sells their paralegal services directly to the public without attorney supervision, also called freelance paralegal, legal technician. In some states, however, the paralegal and legal assistant titles are limited to those who work under attorney supervision. Virtual paralegal. A virtual paralegal works off-site and prepares and drafts legal documents to assist attorneys in their cases and can work from anywhere in the world so long as there is internet connectivity. Document Service Providers, DSPs. 1. A non-attorney who works without attorney supervision to provide legal document assistance to individuals who are representing themselves. 2. Someone who helps another prepare or process documents. Unauthorized practice of law, UPL. 1. Using or attempting to use legal skills to help resolve a specific person's legal problem. When the assistance is provided by someone who does not have a license to practice law, and when the assistance requires such a license or other authorization. 2. A non-attorney's performance of tasks in a law office without adequate attorney supervision, when those tasks are part of the practice of law. 3. Delegating tasks to a non-attorney that only an attorney can perform. Paralegal. 1. A person who performs substantive legal tasks on behalf of others when those tasks are supervised by an attorney who would be required to perform the tasks if the office did not have a paralegal. 2. A person with legal skills who works under the supervision of an attorney or who is otherwise authorized to use those skills. This person performs tasks that do not require all the skills of an attorney and that most secretaries are not trained to perform. Fees. The amount charged for services rendered. Paralegal fees. A fee that an attorney can collect for the non-clerical work of the attorney's paralegal. The fee covers the paralegal's substantive legal work on behalf of the client. Contingent fee. A fee that is paid only if the case is successfully resolved by litigation or settlement, regardless of the number of hours spent on the case. The fee is also referred to as a contingency. Court costs. Charges or fees imposed by and paid to the court that are related to litigation in that court. An example is a court filing fee. Engagement letter. A letter that identifies the scope of services to be provided by a professional and the payments to be made for such services. American rule. Each party pays their own attorney fees regardless of who wins the case. The losing side in litigation must pay the winner's attorney fees, also called loser pays. English rule. Fee shifting. Requiring one party to pay another party's attorney fees and paralegal fees because of prior agreement, bad faith, or special statute. Bad faith, dishonesty or abuse in one's purpose or conduct. Frivolous, lacking merit, pertaining to a legal position that cannot be supported by a good faith argument based on existing law or on the need for a change in existing law. Aggrieved, injured or wronged, and thereby entitled to a remedy. Aggrieved. Statutory fee cases. A case applying a special statute that gives a judge authority to order the losing party to pay the winning party's attorney fees, including paralegal fees and costs. A method of calculating lodestar. A method of calculating an award of attorney fees authorized by statute. The number of reasonable hours spent on the case is multiplied by the prevailing hourly rate in the community for similar work by attorneys. Other factors might also be considered above the lodestar in setting the fee, such as the quality of representation, any delay in receiving payment, and the risk at the outset of the litigation that the prevailing attorney will receive no fee. One, a law firm employee who is in law school studying to become an attorney, or who has graduated from law school and is waiting to pass the bar examination, also called a clerk. If law clerks work only in the summer, they are sometimes called summer associates. 2, one who provides research and writing assistance to a judge. Amicus curiae brief. Friend of the court brief. An appellate brief submitted by a non-party who obtains court permission to file the brief, setting out its views on how the case should be resolved. Timekeeping. Recording time spent on a client matter for purposes of billing and productivity assessment. Leveraging. Making profit from the income generating work of others. Billable. Pertaining to those tasks requiring time that can be charged to and paid by a client. The meeting in which closing. The meeting in which a transaction is finalized. An example is the meeting to complete a real estate sale or other transaction, also called settlement. Billable hour quota. A minimum number of hours expected from a timekeeper on client matters that can be charged, billed, to clients per week, month, year, or other time period. Realization rate. The percentage of total client billings of an attorney or paralegal that the office actually collects, because timekeepers often spend on both billable tasks and non-billable tasks. A further breakdown is a timekeeper's billing realization rate. This is the percentage of the timekeeper's total office time that is billable. For example, paralegals who spend half their time on non-billable tasks and half on billable tasks have a 50% billing realization rate. A signed statement by an attorney that a paralegal applying for membership in an association meets one or more of the criteria of the association, the most common of which is that the paralegal performs paralegal duties. Attorney attestation. Legal advice. A statement or conclusion that applies the law or legal principles to the facts of a specific person's legal problem.